and we're going to get started. Our legal counsel, Abigail, is online with us, and she'll keep us straight. Abigail is 6 weeks away from delivering a baby, and so she decided to stay in Cheyenne today, which was wise of her. Abigail, would you call roll for us, please?
Senator Boner, Senator Driscoll,
Here.
Senator French,
Here.
Senator Guru,
Here.
Senator Steinmetz, Representative Banks,
Here.
Representative Eklund, Representative Larson,
Here.
Representative Nineman,
Here.
Representative Paxton,
Here.
Vice Chairman Hicks, Chairman Simpson.
Here.
Mr. Chairman, you have 8 people present.
Thank you, Abigail. So folks, this is who we are. You notice there was senators and representatives in the roll call. So we're called a joint committee, and we typically function with jointly all the time. And so we're a select committee. That means we're not one of the standing committees. So our job is to deal with all things related to water. And we have a specific assignment to monitor the Wyoming Water Development Commission and to approve or recommend approval all their actions. And then when bills are produced out of this committee, we take them to the legislature during the legislative session and advance those bills the best we can. So the leadership of the Senate and the House gives each committee a list of topics they want us to study. So they're generally the topics that are the hot issues that develop during the legislative session. So we've had 5 or 6 topics we've been studying. So we call this interim meeting because it's outside of the legislative session. Interim means the summer session. So we've been meeting in the summer and in the fall, and we travel to different locations and meet in different cities. That's typical of all the legislative committees. They travel around and give people an opportunity. Since I'm the chair of this committee this year, it gave me the opportunity to pull rank and to force my colleagues to travel clear across the state to come to Afton. We so rarely have that opportunity that we appreciate them and our staff that came out of Cheyenne and many of you who've traveled great distances. So we appreciate you being here. We will have an opportunity as we receive testimony on our topics today for our citizens to provide public input. And so we'll be able to hear from any one of you that desires to comment on any of the 3 topics we'll be discussing today. So we're going to start off with the first topic. Mr. Gardner, would you come forward to the microphone, please, and bring with you anyone that you would like to participate?
Thank you, Mr. Chairman.
Mr. Gardner?
Yep.
As protocol, everyone, when you are invited to come to the microphone, we'd like you to introduce yourself. This broadcast is being broadcast all over the world, and people may not know you, would like to know who you are, and if you represent an organization, that would be good. And we request all people on the microphones to work through the chair so that we don't get debates coming from many different sources. So with that as a protocol, go ahead, Mr. Gardner.
Thank you, Mr. Chairman, and thank the committee for coming to Star Valley. We appreciate having you guys here and hope you'd enjoyed your stay. And the weather's been good. It's better in February, that's for sure. Dave, you want to go ahead and introduce yourself?
Yeah, Chair, I'm Dave Adams. There we go. I'm a supervisor, Teton Conservation District, and I'm also a director of the Wyoming Association of Conservation Districts.
Good. Welcome to our meeting.
And I forgot to introduce myself. I'm the chairman of the Star Valley Conservation District and the president of the Dry Creek Irrigation. So I kind of wearing two hats. So what we wanted to talk about today, Mr. Chairman, was there's some concern in our community for all these ponds that are being built and whether or not the state can regulate them or maybe control them a little bit. They seem to be getting out of hand. And some of the concerns that some of the residents, some of the neighbors have is water quality. There's a water that sits in those ponds and it warms up and then they discharge it into to the Salt River, to other river bodies. What's it doing? Is it changing the fisheries? Is it changing the quality of water in the rivers? And those are some questions that we've been asked as conservation district that we really don't have an answer for. So we thought maybe if we had a discussion before this committee that maybe we could look at some different things to maybe get some better ideas. If these are harmful to our rivers, maybe we need to address those issues and talk about them. Dave has dealt with this a lot more in Teton County than we are here in Lincoln County. So would you just take a minute to talk about some of the things that you guys have seen and what you're doing to try to address some of those issues?
Sure. Mr. Chair, I brought a little show and tell. We've conducted a survey of water, surface water in the county and made maps. And we have what I call the monkeypox map here. And briefly in pink are artificial ponds. And this is the valley, and the insets show, I believe it's from 1945 and 2015 for both the west, what we call the West Bank, and also in South Park. And you can see the extensive development of artificial ponds. Some anecdotal evidence of the effects of this, especially on irrigators. There's one irrigator on the West Bank that turns his water on at the diversion at the Snake, and he gets the water to his field in 35 days after it's filled all the ponds upstream from him. And you can't run an operation like that. Now, I realize people believe that agriculture is kind of a minimal activity in Teton County, and it is economically, but as far as land use, a huge bulk of our land, private land, is active producing ranches and active irrigation. And the activity of these ponds has been fairly deleterious to their operation in a lot of cases. It seems that the county, the state, and various state agencies have well-defined roles, but there seems to be this gap somehow in between where these ponds exist, and nobody really has, responsibility to make sure they're being maintained or operated correctly. And I guess this hearing is to see whether there's any roles that the state can play, to help alleviate this situation, or ways in which the state could help the counties in their endeavors to keep these things under control. Thank you.
Mr. Chairman, we had some landowners come and visit with us, and we had the state engineer's office come and talk, and their hands are kind of tied because they permit them. And the only thing that they're really looking at is, do they have a right to use the water? And do they have a right to they have an access point, and do they have a water right? And above and beyond that, they don't really have any say about how big the ponds are or anything, how they're maintained and how they function. So that's been one of the concerns that some of the landowners have brought to us. And like Dave said, there's really not there's kind of a gap, but the state engineers doesn't really have any say over it. And the counties, Teton County especially, has been trying to get some kind of a control. But we just kind of wanted to bring this up and have that discussion.
Senator Driscoll,
Probably a state engineer question. I don't know if we got anybody in here, but
we do.
uh,
They're going to testify next.
okay, I'll wait for them then, because I want to know if they're making put outlet works in them, because basically underwater rights, you ought to be able to drain them all if you need to, is my understanding.
We're going to find that out.
We'll see. Thank you. Sorry.
So, Mr. Gardner, make sure that I've summarized the issue. So, committee, the question is, are ponds on private property, are they causing an adverse effect to the environment? And you're suggesting you don't know for sure, but you need us to look into it. So, folks in our committee, what we're doing is evaluating whether this is a county local issue, or is it something that needs to be in the state statutes? So we have a state agency that would oversee that and permit ponds property. So that's why we're here today, is to discuss that. Folks, we have a unique opportunity as a legislative committee of bringing in specialists from all over the state. And so we've done that today. We have invited the foremost experts in their categories to talk to us about what they do with permits and help us understand the issues associated with that. So, Mr. Gardner, do you have anything else you'd like to share?
No, I think that's it. Yeah, if there's some others that have a lot more technical information than me, that'd be good to hear from them.
We're going to turn the time over to them. Thank you, gentlemen. You're welcome to take your seats back. And so one of the regulatory agencies is the Corps of Engineers. And we have one of those representatives online. His name is Kevin Little. Kevin, go ahead and click your audio on and your visual on. And would you explain to us when a person that receives when they want to construct a pond, when do they have to get a permit from you?
Good afternoon, Chairman. Thank you. Thank you and the committee for allowing the Corps of Engineers to provide some perspective on this topic. So I was prepared to discuss specifically off-channel ponds. I'll get into, I guess, the basics first. We're tasked with administering Section 404 of the Clean Water Act, which is the discharge of dredge and fill materials into waters of the U.S., including wetlands. And so any activity within jurisdictional waters that requires, the discharge of dredge and fill material to complete the project purpose requires authorization from the Corps of Engineers. So oftentimes with off-channel ponds, the plan is to construct them, adjacent to a stream. When that occurs in an area void of wetland or any stream impacts, then no authorization is required from our agency. Now, when they start to overlap with wetlands or even want to impound a stream, then we get involved and we have different tiers of permits that are available to complete the projects.
So Kevin, explain to me if someone wanted to build a pond on their property and there was already wetlands that was going to be impacted, what level of process is that and what does that entail?
So we do have this conversation quite a bit, especially with new landowners that want a pond. Now, keep in mind we regulate the discharge of dredge and fill material. If a pond is proposed to be in a wetland area or partially within a wetland area, if the manner of construction is to simply excavate the material to dig the pond and place that material directly into an upland or into a truck then to be hauled off to an upland location, that activity does not require a permit. Now, if they're redistributing material in the wetland, landscaping, grading, moving it around, then a permit is required. And we have general permits that are already authorized, and they're largely purpose-based. And the most common one we use for projects like this is a habitat enhancement. It's a nationwide permit 27. That's a general permit. The general permits are designed to authorize projects that would result in no more than minimal impacts. So our review for anything that would qualify for a general permit is usually pretty straightforward, pretty streamlined. If the purpose of the pond does not meet the intent of one of the nationwide permits or exceeds the thresholds, typically a half an acre of wetland loss, then we go into a standard permit process, and that one is a lot more involved. It starts off with a public notice. Then we look at alternatives to, are there alternatives out there that can meet the purpose and need of the project without needing to be situated within a wetland, et cetera. So that's a lot more involved process. And I guess for perspective, you know, we do 1 or 2 standard permits a year in Wyoming. We're usually able to avoid and minimize impacts to aquatic resources and keep projects within the nationwide permit program.
Thank you, Kevin. So if I understand what you're saying there, if I owned a meadow and I wanted to build a pond, I would go through your process. Do you ever reject those? They're just required to meet your requirements. And if they do mitigation efforts, then they would eventually satisfy your requirements and you'd authorize them.
Correct. Yeah, and I wouldn't say, you know, we haven't denied a lot of actions, but the process itself has, people have opted to stop trying at some point along the way for a few reservoir projects in the state. But yeah, more often than not, we're able to get through the process, which include a big part of that is replacing any wetlands lost or stream functions lost due to the construction of a pond or reservoir.
So in your permitting process, water quality does not come into play?
So for we work jointly with the DEQ for state waters, and then also EPA for waters on tribal land. And there's it's section 401 of the Clean Water Act that goes hand in hand with our process. So if a project is large enough, it would require an individual review from DEQ. Otherwise, the nationwide permits have a water quality certification that's already been granted by the state with a run of general conditions that would apply to all projects.
Okay. Members of the committee, do you have any questions for Kevin? Good. All right. Thank you, Kevin. Appreciate you taking time and to visit with us today.
Thank you, Chairman.
Okay, our next guest that we've invited is from the state engineer's office, and his name is also Kevin. Kevin Payne, would you come up and introduce yourself to the committee?
Good afternoon, Mr. Chairman, committee members. My name is Kevin Payne, and I'm the superintendent of Water Division 4. I'm based out of Cokeville. I might also point out that we have online with us state engineer himself, Brandon Gephardt, and I believe we also have our superintendents out of the other divisions joining us as well. Would you like me to go through our permit?
I'd like you to jump in because you are the one state agency that monitors ponds. And so we'd sure love to hear what you actually do in your responsibilities.
So 41 or Wyoming Statute 41-3-301 basically deals with our applications for reservoir construction permit and requires that an application be made to the state engineer for any beneficial use of water within a pond. We also have our surface water rules, which is chapter 5 that
deal with ponds and off-channel ponds and dams and reservoirs. I've neglected to mention that Jed Rockwyler is also on the line. He is our assistant administrator with the Surface Water Division. And they typically deal with the permitting in the ponds. We typically deal with the regulation of the ponds and the regulation of the ditches in the field with the superintendents and our field staff. So as far as the permitting goes, it may be good that we have Jed on the line that he can answer some of those actual permitting questions. But as far as the enforcement goes, I'd be happy to answer any of those as well. Basically, the state engineer, once he receives an application, is required to issue a permit. There's only a few reasons why they would not. So under that is the Wyoming Statute 41.4.503, which has to deal with what he may judge that would not be beneficial use, or what would be not in the public benefit of water rights would be one of the only things that he really would deny a permit on. There is also, if there's not enough appropriable water, but that gets a little tough because even 1 day a year may be considered appropriable water. So typically, as a matter of course, they will issue permits over, even on what's sometimes considered over appropriated streams.
Representative Nyman.
I hate to interrupt, but my mind is over half a century old. And if I don't ask it now, I won't ever ask it. In what you just said, you guys control. If somebody comes and builds a pond and there's a pre-existing water right, prior right below them, you guys control of that is determined, that permit is then has a determining factor on whether or not that can even be held, because that prior right controls that flow of water or that amount of water that's being adjudicated to that property. Did I understand you correctly when you said that that has to be a part of the determination of whether or not that pond can even be built?
Mr. Chairman, Representative Nyman, I think I understand your question, but let me make sure. So the question is whether we need to consider other appropriations, whether it be down a ditch or down a stream prior to that. That is something the state engineer can consider and does consider. However, most of the time, as a matter of course, the permits will be issued because, springtime runoff, let's say, there's plenty of water for every appropriation on the stream. So that 1 day a year, even if it is, then they may have the right to have a beneficial use of water, and every priority would be satisfied. And so even if it is for that 1 day a year, the permit would be valid and could be sought, and the state engineer would likely issue it.
Go ahead, Senator.
Means we're chasing rabbits. I'll join in. I'll probably, with your permission, Mr. Chairman, ask kind of a series of back and forth without lots of formality. Can I do
Okay.
that?
Please proceed.
What's your procedure for unpermitted that show up? Because there's lots in our country and they're just there. And I know I've gone and talked to them. They're like, well, whatever. And part of them are in stream in our country. So what's the process when somebody hasn't permitted one?
Mr. Chairman, Senator Driscoll, the process is that they should have sought a permit prior to being built. However, we realize there are many ponds out there that have been built without the benefit of a water right. And we work daily to try to get those into compliance. We really don't go out and try to twist people's arms. We try to ask people to come into compliance. So as we find ponds that are without the benefit of a water right, then we ask them to get them permitted. A lot of times the way we find out is people complaining to us, and we do the best we can of getting out there and trying to get with the landowners and getting those ponds permitted.
Thank you, Mr. Chairman. Follow up. So one, do you make them put drains in all of them? Because like the ones in our country, I know Representative Nyman's under the same as us. We're under regulation or close to it now. And my understanding has always been you can go to the top of the drainage if you've got the first right and drain virtually every pond top to bottom. Is that assumption correct? And what do you do when there's ponds, because I've got some substantial ones above me that have no drains in them. And then last piece is, do they take into effect on off channel? So I go dig a big reservoir off channel and I divert the stream into it. Do they take any consideration for the first 60 days that the water just goes in the ground and disappears, and they really don't fill it, but they stop all the flow of the stream from coming down into the use at the bottom? Thank you.
Yeah. So, Mr. Chairman, Senator Driscoll, as far as addressing the outlet works first, oftentimes there are many reservoirs that are built without outlet works on them and are permitted that way. However, typically there is a requirement that says that if any time we need the outlet works, that we could require them to be installed, and the state engineer can do that, or the superintendent can order in whatever is needed to have regulation be successful. As far as your other question is down ditch and what's required. Once again, the outlet works may not be required, and sometimes we do get called to regulate. And so is your example of a reservoir that would take 60 days to fill, that may be injuring other appropriators, and that would take a request for regulation to one of our hydrographers, and they would go verify that that senior right was short, and then they would go satisfy the senior right.
Mr. Chairman.
Go ahead.
So you don't know you're short 60 days ahead. I guess that's where I'm at is, so we're in late May and runoff's kind of over. The creek's running 2-3 second feet and they're diverting it into an off channel reservoir. And we're just starting to irrigate. What's the recourse and the policies on how it works? We're kind of confused. Our area, and I think I keep referring to Representative, we really haven't had much for regulation in the past, and we're all getting lessons on what regulations like and how it works. Are you the same as me?
Oh, yeah.
We're learning.
Do you have any more questions, Senator? You're good?
I asked.
So
They really do. You know, we've got lots off channel. They divert those all the time. And then we're irrigating downstream. And so we've got all our irrigated ground. And then all of a sudden they're like, now your stream doesn't have the flow to carry your right. Yet they're still running water into either in-stream diversions or off stream. And I'm trying to figure out how to do it without having my neighbors come down and burn my house down.
Kevin, do you want to answer that, or do you want to phone a friend? You're welcome to do that.
sure, I'd be glad to take a shot at that. And then if somebody else would like to jump in. Mr. Chairman, Senator Driscoll, to your question, we do not proactively go out and just shut rights off. It does require somebody to request regulation and actually demonstrate they're being shorted. And they also need to, at the same time, demonstrate that they're not bypassing water. So if this was on a natural creek channel, that the water right was short, they would need to prove that they're actually trying to utilize and block and get all the water they can. And still, if they still remain short, then our hydrographers will start shutting off priorities, most junior first. And we typically have, by our strategic plan, we try to have that done within 2 business days of when we receive that request, at least to get started on it.
Mr. Chairman, follow up.
Okay.
Sorry. Well, it takes time. I'm getting some lessons here. So requests for regulation, do they have to be in writing? What's the procedure? How do they do it? And then, of course, we're, at least where I lay and Representative 9, we're on a state line. What's the process for the other state to call for regulation? Because do they have to do it in writing, and do I have to be informed some way? Or do they just drive up to my house and say, well, we're in regulation?
So, Mr. Chairman, Senator Driscoll, the form is typically one that it does have to be in writing it. And the form is on our website. And our hydrographers typically have the forms as well, and they can issue them at that point. So any of our offices in the state would typically have that on hand and be ready to deal with that signature.
Other questions?
Another state. South Dakota has
So-
to do a written form.
Now that is a little different question. And we've had some interesting litigation on it. And of course, with Montana v. Wyoming, it was also brought up on that end of it. But sometimes it can be as simple as a phone message to request regulation across state lines. It could be trigger points based on the compact. It could be many things of how that works.
Good. Other questions? Director Gephardt, welcome to our meeting. Would you wave in the air so all of our guests know who you are? This is a state engineer, and he's been in that seat for about 6 months, so it means he's an expert. Thanks for joining us, Director. May I ask a question of Jed? That be all right?
Mr. Chairman, please do.
So Jed, how many permits do you deal with in a year, statewide water rights for ponds?
That is a good question. Unfortunately, I don't have that information readily available.
Kevin, would you have an idea of just in your district, how many ponds permits you deal with each year?
You know, I wouldn't have a really good estimate, but I would estimate probably over 100 within my division.
Over 100. And you cover 1/4 of the state.
Yes.
So let me make sure that I summarize what you've instructed us on today. So if I have a piece of property and I want to build a pond on it, and let's say I have an irrigation ditch that runs through it, I would apply to you for a permit to do that. And there's 2 types of permits or water rights that I could acquire. I could acquire a 2022 dated water right for that pond, which would be a current water right for the pond. Or if I chose not to irrigate around my pond, I could take those water rights and apply to you and convert them, an irrigation water right, into a pond water right and retain my earlier date priority, which would account for seepage and evaporation. Is that correct?
Mr. Chairman, that is basically correct. If you was to come in today and seek a new permit application for your 2022 priority date, you could do that through the state engineer. If you was to try to convert the underlying water rights to the pond supply, then you would need to come to the Board of Control for the change of use. That would change the use from likely irrigation to pond supply. And that would be the procedure behind it.
And the Board of Control is your cohorts, the 4 of you and the state engineer, is that correct?
That is correct, Mr. Chairman, and the other superintendents are online as well.
Okay. All right. Any other questions for the state engineer's office? We have a feel for that. So one more question for you then, Kevin. I want to make sure I'm clear on this. If they do all the mapping, show you where the inlet outlet is, the contours, the information, then they provide it to you, you're probably going to approve the permit, because if they comply with one of your water right regulations, then they're good to go.
Mr. Chairman, I would say that is very likely that they would, if they are in compliance with all the terms of their permit, or if they come in and ask for a permit, they would receive a permit if they followed all the procedures laid out.
Thank you. And do you perform inspections during construction?
Yes, Mr. Chairman. So once the state engineer issues a permit, then they file a beneficial or the BU notice that they have actually put that to use. And once that happens, then what's called a proof that we refer to is generated, and our board staff will go out. So my staff that's in Division 4 out here would go out and look and make sure it was built to the specs of the permit. They'd require a fee of $70, and they would make sure that everything was built exactly as it said in the permit, and then it would be advertised in the newspaper. And then if no protests were formally lodged, then it would be at the next board meeting, whenever we discuss surface water proofs or groundwater proofs, whichever one it would be adjudicated at that point.
And do you require any type of fish screens, or what is the outlet works requirement from your agency?
It would probably be better question for Jed of exactly what's required on the permits.
Okay, Jed, can you help us with that question? What do those outlooks typically look like?
What do outlets typically look like?
Yes, the outlet of the pond.
Well, it depends. There's either a low level outlet or a higher level outlet, just the spillway. Some ponds don't have a low level outlet. If they don't, we condition them so that a low level outlet or a bypass ditch may have to be put in place later if it's necessary for regulation. Otherwise, a high level outlet is just what's going to control the water line of the reservoir, depending on if it's a dam or a pit. That's going to be something that releases water from the reservoir in order to keep the water from overtopping the dam.
So Jed, a follow-up to that. So in your permitting process, the state engineer does not consider water quality or fisheries in your permitting process. Is that correct?
Correct.
Thank you. Okay, one last shot. Any questions for the state engineer? All right. Thank you, Kevin. Kevin burned home all the way from Cheyenne last night just to be here. We appreciate him being live with us. We're next going to hear from the Wyoming Department of Environmental Quality, Jennifer. Jennifer was selected by her department head as being the foremost expert on the subject. And so we look forward to hearing from you. Thanks, Jennifer, for coming all the way to Afton.
Sure. Thank you, Mr. Chairman. Again, my name is Jennifer Zigmant. I'm the administrator of the Water Quality Division for the Wyoming DEQ. And pleased to be here today to talk to you about the permitting and regulatory requirements that we have for these ponds. I think, as you can imagine, the water quality impacts do fall within our authority to regulate and permit the aspects of pond construction. But similar to the other agencies, our authority is to make sure that pond construction and any subsequent activities meet water quality standards, don't cause violation of water quality standards. But as long as our requirements are met, we would issue the permit. We don't have that ability to say yes or no to pond construction, again, if it meets our requirements. So for the type of ponds that we're talking about today, DEQ would refer to those as on-channel ponds. They have an inlet or outlet to another surface water, or maybe they're built within the floodplain of a river or stream. So our regulatory authority is, again, to make sure during pond construction that water quality standards aren't violated. You heard from Mr. Little with the Army Corps that they issue the Section 404 permits for dredge and fill activities on jurisdictional waters. DEQ does issue 401 certifications for those 404 permits. So we work with the Army Corps, and our job is to make sure that that project will not, again, cause an exceedance of our water quality standards. And we do that by putting in conditions into these certifications. And those certifications cover a pretty broad range of activities related to that discharge. General measures to prevent spills, best management practices to reduce sedimentation and turbidity, vegetation restoration requirements, bank stabilization, and other general conditions to make sure that we're not introducing pollutants into a water body. These ponds, once they're constructed, are considered surface waters of the state. So they would be protected according to our rules and regulations, according to their designated uses. Those uses being things like cold water fisheries, warm water fisheries, drinking water use, or other aquatic life. So again, our permits and our standards would apply to those ponds. Once they're built, they are surface waters of the state. We investigate issues on private ponds as we become aware of them. Typically, that happens as a result of complaints that we receive. If we receive a complaint, we'll work with the individual to get more information. If there is a water quality concern, we will go out and investigate that. If it involves a 404 permit, we will coordinate that investigation with the Army Corps of Engineers. And we usually work with the landowner through conference and conciliation to address any issues. And usually those issues are, they just weren't aware that permit coverage was needed. So we'll work with them to obtain the permit coverage that they do need. There's a lot of I think, areas with pond construction that can fall into some gray areas. So that's where I think it's important for us, Army Corps and Game and Fish, to be working closely together to make sure we're sharing information when there's unique situations. And I think that communication is occurring. If we, again, become aware of a water quality problem due to one of these ponds, we'll take a look. It may involve some additional monitoring. And when we're talking about concerns on a watershed basis, for example, we heard on the tour today that there's concerns about thermal loading from these ponds. Is it increasing the temperature in the Salt River, for example? I think that's a question that we're going to have to look at on an individual basis, but we are happy to work with the conservation districts and other partners in the area to see, how would we be able to tell if those temperature increases were from these ponds or due to other sources? Given requirements in our water quality standards, it's important that we'd be able to show that those temperature changes are related to the pond construction and not natural changes in temperature. So, Mr. Chairman, I'll stop there and see if that answered your question or if I can answer any other questions.
Thank you. Questions for DEQ? Senator?
Thank you, Mr. Chairman. Jennifer, how many of these type of complaints does your department field a year?
Thank you, Mr. Chairman. I would say we received more complaints in the past. I would say currently we're probably only receiving maybe 1 or 2 a year. It's pretty rare right now where we are getting those complaint calls.
Mr. Chairman,
Please.
is there any coordination at all with state engineers office and you folks as far as, I know they answered the question whether they do it, but is there coordination between you folks at all?
Yes, Mr. Chairman, we do coordinate with SEO when we become aware of a complaint. If that complaint involves some kind of water rights issue, we will pass on that information to SEO and make sure that they are aware of it. But again, our authority lies only within water quality. Anything with water rights will pass on to SEO.
Jennifer, I think you answered this, but there was a squirrel that ran across the floor there for a second for me. So if I'm a property owner and I want to build a pond, I'm going to make an application to the state engineer's office. Do I also, is it state statute that I have to make an application to DEQ?
The application for these on-channel ponds that we're primarily talking about today, typically if they come in for a 404 permit, the 401 certification process is coordinated with that 404 permitting process. So it's not a separate application to us, but we do review the 404 permit.
I see. They send it to the Corps of Engineers first, and then they CC you. And what criteria, when you receive one of those, what are you looking for? And do you have input all the way back to the property owner? How does that work?
Thank you, Mr. Chairman. So we review the information that we receive. And again, we look at the activities that we do and evaluate it against the nationwide permit that it's being authorized under. Mr. Little mentioned the nationwide permit number 27, and that is the primary permit that we see that we're issuing 401 certifications for as well. So we look at the activity and make sure that that activity is complying with our requirements that we would want to see to make sure water quality standards are being adhered to. Again, those are conditions that we put into the certification that gets communicated back to the permittee. And those conditions have to be met. Again, things like they have to have BMPs in place to make sure that erosion isn't happening, spills don't occur. If they're putting any kind of structures within the water body, they would have to construct them according to certain specifications.
And Jennifer, how many of those this last year did you receive in a 12-month period?
Yeah, thank you, Mr. Chairman. I did ask the gentleman who does our 401 certifications, and just for context, we have issued 9 401 certifications under that nationwide permit number 27 within the last 2 years within the Star Valley area. I should say Lincoln County.
Lincoln County.
Correct.
9. Okay. So Jennifer, when a developer wants to do a subdivision and he's going to use wells and septic tanks, it's required of him to go hire an engineering firm to evaluate the quality of water impact to that the septic tanks would have on the groundwater. And that comes to your agency. Your agency reviews those.
That is correct, Mr. Chairman.
But there is no requirement for that same subdivider that wants to do a traveling pond through his subdivision. You would only see that if the Corps forwards that. There's no specific requirement for them to fill an application and send it to DEQ for a pond.
Correct. We would not see an application for a pond similar to what we would see for a subdivision review, which is required by state statute. As you indicated, a subdivision review application comes into us. We look at it in terms of safety and adequacy of the water and wastewater systems, and then we don't approve or deny that. We issue either an adverse recommendation or a non-adverse recommendation and send a letter back to the county commissioners who ultimately have the decision to approve or deny that subdivision application. But there's not a comparable process for land development ponds.
Thank you. So if this body chose to prepare legislation, a bill to go through the legislature that would then require developers to come through you. You indicated there's less than a dozen in Lincoln County. I'm thinking Lincoln County right now, well, perhaps Park County, but we're probably seeing the biggest impact. How is this going to affect your agency? Do you think you're going to have to add an extra employee to manage that program?
In theory, Mr. Chairman, I believe we would. Again, we're pretty limited on staff resources right now. We have one individual who does all of our 401 certifications. I'll note that our subdivision reviews go through a different section. They go through our district engineers. They're the staff that review those. With the number of subdivision reviews that we're receiving, those are increasing as well. To add another comparable, similar process, I do think that we would need to have additional staff resources at that point.
Good. Thank you. Any other questions? Anyone online that would like to ask a question? Very good. Thank you, Jennifer.
Thank you.
Appreciate your attendance. Okay, we have yet another specialist that's going to address us. We've invited the Wyoming Game and Fish Department to send their specialist on this topic. Paul, would you come forward? And would you like to introduce yourself and tell us what you would like to share with us on this topic?
Thank you, Mr. Chair. My name is Paul Day. I'm the Aquatic Habitat Program Manager. I'm based out of Cheyenne with Wyoming Game and Fish Department. And I prepared a few bullets of information to share with y'all, and then I'll attempt to answer any questions you may have. I guess first off, Wyoming Game and Fish Department does not have direct authority as it relates to pond development. We do have permit authority, however, as it relates to stocking private ponds with fish. So, for example, if a private landowner desires to stock fish, they need to apply for a permit through the Wyoming Game and Fish Department. They'd be limited in the species that they could stock. The fish must come from a Wyoming Game and Fish Department approved private fish hatchery that has been tested for native for AIS and invasive species. Around here, Snake River cutthroat trout would be a priority. We'd be trying to protect that fishery primarily. As an example, for permitting numbers in this area, in the 5-year period from 2017 through 2022, we had 24 stocking permits, annual stocking permits that were issued for ponds in the Upper Salt River watershed, basically upstream of the Narrows. Statewide, we issue in the neighborhood of 500 stocking permits per year. Just in regards to some general comments about ponds and potential issues, aquatic invasive species can be an issue with pond development, especially if the landowner stocks fish. That's a potential vector. Through our permitting process, we attempt to minimize that risk. A number of years ago, rusty crayfish, for example, were illicitly stocked in private waters and remain a concern today. So that's sort of the thing we're trying to guard against. Those permits you learned about from Mr. Little and Ms. Zygant do provide protection against AIS. Some of the conditions included in those permits include recommendations to reduce that risk. Our standard comments include guidelines for fire equipment, and I guess by extension, you can extend that to excavating equipment as well. And that primarily revolves around cleaning the equipment, getting the weeds off, getting the mud off, and trying to avoid moving water. That's really one of the riskiest vectors, I guess. And I guess if non-native fish do get established in a pond, you know, essentially there's a pretty good chance they're going to end up in a nearby waterway. You know, our main role here maybe as a technical advisor to county planning and zoning authorities on pond developments. Our habitat protection program, we call them HPP. They often provide comments on project proposals around the state. I know some counties consult pretty regularly with the department and others less so. Lincoln County could pass along development proposals for our review, and we'd be happy to provide some technical input on, you know, what potential risks or benefits even there might be for wildlife and fisheries and wildlife. Typically, we turn those around in about 30 days. In addition to stocking and AIS, ponds can involve other wildlife issues. In the northeast part of our state, HPP, our Habitat Protection Program, has provided comments on reducing insect-borne diseases. We worry about blue tongue, for example, a disease that deer get. Mosquitoes spread that. My understanding is there's been a fair amount of pond development associated with the mining industry in that area. And in order to minimize the mosquitoes, we've got technical specs on how to slope the sides and how to sort of construct that pond, at least to minimize those sorts of issues. Our typical comments also advise against or advise as to how to avoid impacts to the riparian areas. If a pond development involves diverting water away from a flowing stream, obviously there can be some potential impacts to fish there, depending on the specifics of the location. Private ponds have resulted in unwanted wildlife conflicts in more developed areas. We've had a history of, for example, nuisance moose calls in the Jackson area over the years. And of course, geese can be attracted to ponds and make a mess. I've seen that on golf courses. But certainly the right pond in the right place can have great wildlife values as well, no doubt about it. In the river restoration work our folks do in the department, very often we're looking to narrow streams up and we're looking for fill material. And one way to do that is to construct a wetland and a pond. At the same time, very often we need to mitigate any loss of wetlands and create, you know, more wetland than we damage. So we're often interested in that as well. So I guess in conclusion, Game and Fish is accustomed to providing sort of technical comments and insights and recommendations related to pond development, and we'd be happy to provide that service to zoning and planning authorities in Lincoln County or elsewhere. And with that, I'll attempt to answer any questions, Mr. Chair.
Good. Thank you, Paul. Questions? Go ahead, Senator.
These ponds, do you ever, once they're constructed and maybe somebody wants a permit to stock it with approved fish species, do you ever go check to see if maybe they threw walleye out in their pond or something that wasn't approved and or a species that wasn't approved that potentially could get in a stream and on down to a lake or whatever?
Mr. Chairman, Senator French, I think in terms of our checking, that would come on the front end. Our regional fisheries staff, which in this region is located out of Jackson, if it's a new stocking, a new pond and a new stocking event, very often they'll want to see it in person to understand sort of where it is and how it might connect to a flowing river nearby, like Salt River. But after that, it'd be pretty much hands off. We do conduct fisheries monitoring sampling periodically. And if a species like that showed up, then we'd be doing an investigation to try to identify the source and where that might have come from.
Paul, I've got a couple of questions for you. So if I want to build a pond on my property that has a flow through canal on it, if I'm not going to stock it with fisheries, you would not know, you're not involved in my construction process. Is that correct?
Mr. Chair, to a large extent, that's correct, except as Ms. Zygmunt from the DEQ noted, we work fairly closely with the Corps and the DEQ and their permitting processes. They'll very often CC permits to us, so we're aware of those activities. And if we have wildlife concerns, we'll very often bring those up. But that would be our only sort of indirect connection.
So Paul, if I want to build this pond, I build it, no big deal in my field. But 2 years later, I decide, guys, it'd be nice to have some fish in there. Then I could not just go buy fish from a private fish hatchery. I would have to acquire a permit from you first. Is that correct?
Mr. Chair, that is correct.
And when they make that application to you for permission to stock their pond, do you look at the pond outlet structure to determine if the fish are going to be able to escape and enter waters of the United States?
Yeah, we would desire, Mr. Chair, we desire information on that connection. So inlet and outlet and how it might be connected to public fisheries and waterways.
Very good. Thank you. Senator.
Thank you. Paul, let me make sure I understand this correctly. So if a 404 permit's applied for and the DEQ does their 401 certification, at some point in that process, the Game and Fish gets a heads up. Is that just an automatic part of that process? Is it just something that occurs at certain types of permitting or that, certain size, certain whatever?
Mr. Chair, Senator Guru, for the nationwide 27 permits that were discussed earlier, we'll generally see those at some stage in the process. And as to the details, further details on that, I would defer that to the DEQ or Corps.
One follow-up.
Go ahead, Senator.
Thank you, Mr. Chairman. And did you mention, and I may have seen that same squirrel come by, I don't know. I just missed it. Talking about water temperature and water temperature variations because of ponds, is that something that you all take a look at as well?
Mr. Chair, Senator Guru, we don't look at that directly as part of, say, a pond stocking or something like that. I think with our responsibility in conserving and protecting, the public's fishery in the Salt River, for example, if there was an impact somehow through whatever activities on that, that's where we'd, have concerns.
Thank you, Mr. Chairman.
That stimulated a thought. So the Corps of Engineers gets involved if there's wetlands or a structure in a water course. But in my agricultural field, I don't have wetlands. I have a cow pasture. And if I want to build an irrigation, a pond off an irrigation ditch, then neither you nor DEQ nor the Corps would be involved in that.
Mr. Chair, that's
is
my
that correct?
understanding.
Yeah. Okay. All right. Any other questions? Any of our Zoom candidates like to weigh in here? Representative Larson, you've been kind of quiet today. All right. Thank you. Thank you, Paul. We appreciate your attendance today, coming all the way from Cheyenne to be with us. Okay. Oh, I do have a question. Director Gephardt.
Thank you, Mr. Chairman. It's less of a question, but maybe a little discussion after hearing some of the other panelists. And a couple of things that struck me. Kevin alluded to in his discussion, kind of the narrow window that we're provided to deny a permit. And I think he illustrated that fairly well. But we understand that there is an issue with some of these ponds. And one of the things that maybe we could commit is that if the counties were zoning and their rules or policies, we would be happy to work with them in developing those policies from our perspective and what we see and what the issues are. So if a county were to try to develop policy to help address some of the issues that are occurring, our agency would certainly be willing to help in establishing and reviewing those policies and inserting our thoughts and our experiences into that as well. I know Paul mentioned that some of the county planning zoning reach out to them, and in developing those policies, we'd certainly be willing to help out.
Thank you, Director. Appreciate that. So committee, before we start debating this, decide where we want to go with it, there's quite a few people in the audience who would like to comment. And so I'm going to open it up for public comment right now, and let's hear what they say before we start giving ourselves direction. So folks, at this time, you are welcome. If you would like to talk about this particular issue, please come up to the microphone, push the button, the green light comes on, introduce yourself to us for the record, and then share with us your thoughts. If any one of you get carried away and take up too much time, I'll gavel you out and let you know that we need to share the time. But please, anyone come on up. Mr. Brogue, come on up and get us started. Mr. Brogue, would you push that button, the middle one? There you go.
Yeah, now it's green.
Good.
I live in Wyoming because I like clean air and I like to be the first to use the water. And so my concern is that I'm not being the first to use the water anymore. And so I have a couple of comments on the issue. And when we started this discussion is that we started it with aquifers. Down in Freedom, I live on a lake, and I don't know that the permits and what we do here perhaps take into consideration the whole extent of the water the watershed that we live on down there. And so the concern is when people come in and they want to do a subdivision. And so to make a subdivision beautiful, they have to have at least 2 acres of pond. And this is not part of the discussion, but the roads can't even be straight. They have to be crooked, but we'll have to live with that one. But my well is 21 feet deep. There's a pond adjacent to me that if you look at it, and the pond is not because it has any water coming into it or any water going out of it. It's actually the lake or the aquifer, as we call it. And that aquifer, with my pump being about 21 feet in the ground, and that's I take one length of pipe, I stick it in the ground, and on the bottom of that thing is where my pump is. It's about a quarter of a mile from me. And if there's an pond there and they're at say 15 feet or at 20, that's way too close for me. And that's my concern. Well, as I have listened to this discussion, to get a permit, that's not a big deal. We can come up with a permit. We have some guidelines on that. But if somebody comes in and says, well, I want to build this pond, and this is what I'm going to do, then how do I know? Let me back up a minute. I've had some experience. There's a fellow in my neighborhood that built a pond. He says, I'm going to have this pond and I'm going to make sure that you have enough water to water your livestock. This summer, that went dry. I didn't have the water and nobody said anything and nobody talked to him about it because he has a permit. Everything's fine. Okay. Except that I don't have water. And part of the discussion is when he got his permit that we were going to have water coming down so we could water our livestock. That didn't happen. The next situation that we have here is when I have drinking water and I can't drink, and it's too late because he's gotten the permit. He's done everything he's supposed to do, but I can't my own water and it's not my water and it's not his water. And I don't know whose water it is after listening to this discussion because I live on a lake. I can watch Tin Cup down there, and as soon as high water comes, I can tell where the water table is. It's not my water or his water or anybody's water. It's all of us is our water. And I want to do something about it before it's too late, is what I'm saying. And I don't know what to do about it. Anyway, I don't want to take all your time here, but that's my concern. And I'd appreciate somehow so that when I go and turn on my tap and have a nice cold drink of water, I'm not thinking of all the other stuff that may be in it, because to this point, it has been really good water. Thank you, Mr. Chairman.
Thank you, Mr. Grove.
Better get somebody else coming because it'll take me a minute to sit down.
We don't want them to trample you. Anyone else? Come on forward.
Good afternoon, Mr. Chairman,
Thank you.
members of the committee.
Please-
My name's Kelly Lockhart
Thank you, Kelly.
with Lockhart Cattle Company. I'd not really intended on commenting on this particular item, but since I'm kind of long-winded on other items, I thought I would take this opportunity. My experience with ponds goes back about 50 years in Teton County. And my experience is, quite honestly, that ponds are regularly built. There's very little permitting. You heard what it takes. A lot of times I find out a pond's being built by, I notice the creek's kind of muddy. So I drive up the creek until I find a track out. And I drive out and find out who's building the pond. Typically it's in front of a house. And they want to see their reflection and maybe the Tetons. So I then make a phone call or two and find out it's permitted or not required to be permitted. That's kind of how it works. I'm a kind of a property rights guy, so I'm not for a lot of regulation. Not necessarily for a lot of county regulation. On the other hand, these ponds, there are good ponds, as Mr. Day said, or someone that are very beneficial. A lot of them aren't. My experience also is that with a pond permit, if there is, there's a lot of time and enlargement for a water right. And as you know, the Snake River has unadjudicated water. So if you're in the neighborhood or you have water right, you get notification from the state engineer's office. Of course, I always write back and say I'm not for it. Because typically a pond right is, depending on the size of the pond, and it's not my field for expertise, but a lot of times it's about the flow is about a garden hose. Well, we have very porous soil or gravel. We don't really have any topsoil, so garden hose is not going to fill a pond. And as Senator Driscoll said, you know, when the water gets turned on, they fill up all the ponds, and it has nothing to do with the water right. Again, we don't have control in Teton County. We don't want control in Teton County. I'm going to talk to you a little bit later about that sort of stuff. But there's really not any difficulty in getting these ponds done. There's really very little, if any, enforcement. My concern, and I was going to mention this in later comments, is that person has a water right. And as I saw in a later item, you know, they then have an ability to go upstream in that ditch, and they have an easement to be able to do whatever they want with that water right. Not whatever, but maintain the ditch or the conveyance. So what I'll find is this, some of these owners will come on up the ditch, pull my dams, pull my boards out of the head gate, and get whatever right they want. And when you go talk to them, it's, well, I have water right. You call the state engineer's office, state engineer, very nice. I've talked to a lot of state engineers over the last 50 years, a lot of their regional people, and they say, yeah, that's a problem. If you want to call for control, you know, we'll start to institute that. It's a little bit frustrating. Some of our water rights go back to about 1896. Some of these enlargements, you know, are 2021, 2020. And so you got a pond guy that's on your property, pulling your boards, getting water. You confront them. Yeah, I got an easement. I'm going to be able to do what I want. Call the state engineer. The state engineer, like they said, well, we get involved with that. But if you want to call control, but what you can do is it's a civil issue. And so it's a civil issue. Well, some of these owners, they got more time, more money, and they kind of like to have a little task at hand. So, you know, it's not something that I need another job trying to figure out how to control the water that's going in my irrigation ditches. So I would like you to address the easement issue in the bill that you're going to consider later today. And this is an opportunity for me to talk about that, not on that time, because just because you has an easement, whether it's an irrigation water right, a pond water right, that can cause a lot of problems. And it can cause a lot of problems in terms of if there's happens to be destruction to the infrastructure, the head gate. Some of our head gates are old, you know, wooden head gates that, you know, are not as fancy as the ones we looked at on the tour this morning, and they can do damage. And if you act like you're not going to give them their way, they can do damage to your head gate. They can literally come do with your water. And we don't have time to have another job of just monitoring every head gate. We have about 9 ditches. And on those 9 ditches, I can't tell you how many neighbors. None of them are a district. So we don't have a ditch rider. Nobody measures anything. So I would caution you in terms of this whole pond issue to look at it in terms of what, I don't have an answer for you in terms of legislation that you might want to do. But I will tell you that this is significant. You saw the map from Teton County Conservation District. I have ponds all around me, and it is an issue. And I'm glad that you're in those seats and you're a lot smarter than I am. So good luck with this one. Thank you.
Thank you,
Yeah,
Paul.
I'm open for questions.
Representative Nyman.
Thank you, Mr. Chairman. Curiosity, you have a priority right on this ditch, correct?
We do.
So why do you have to put up with folks coming up and releasing your water if you are using your allocation? I mean, that would be the responsibility of the state engineers or the Board of Control to be able to come up and say you can't be messing with somebody else's property. So what is the situation? How does that develop? And the fact that they believe that they have a right to the water, do they have a right to a full pond, or or is there a right to a flow amount, or what are they thinking?
Well, they believe that they have a right to a full pond. And they have a water right, which may or may not allow them to have a full pond. When you call the state engineer's office, and again, the state engineer's office is trying to do the right thing. It's just that they're not an enforcement arm. State engineer's office is not an enforcement arm. What they will tell you, and again, you have state engineer people, so I shouldn't be answering them, is that it's a civil issue, especially downstream from point of diversion. If there is a request for control, I've also been told that the control happens at point of diversion. Now, as you all know, or most of you, downstream water rights, then you start to allocate that usually through an irrigation district. We're a little bit lawless in Teton County. We don't have irrigation districts. We don't have ditch riders. We don't have any of that. So the issue is that the remedy, even if the law were in your favor, is civil suit.
Mr. Chairman,
Nyman.
follow up.
Go ahead.
Are you taking more water than what your adjudication allows?
In Teton County, we're very fortunate. There's unadjudicated water in Teton County. And generally during flood flow and high water, we're very fortunate to be able to use, I won't say more than we're adjudicated. There is no measurement. So I don't know the answer to that, but we're very fortunate that we have a lot of water a lot of times of the year. Sometimes of the year, we do not.
Mr. Chairman, follow up.
Good.
Okay, here's a situation I'm currently facing, and my guy is on there. There he is in the middle on the right-hand side. I have an adjudicated water right for 1.5 CFS on a stream. If that stream is not producing, if that stream is producing more than that, I'm entitled to my full adjudicated water right to go to that designated property, to that ground. If it falls below that, or I'm not able to receive that amount because it's above me, and I have to call, like what Senator Driscoll said, others are taking the right that I have a priority date, which allows me to take that much water. The question I guess I'm wanting to get to here is, if you're taking what you've been allowed to take, and it is just so happens to be exactly what that stream is producing, then you have the right to take 100% of that under your adjudicated right. I guess my question is, if there's more than that and there's nobody that's being able to determine that amount, do these downstream users or permit holders believe that they have a right to the water that is above your appropriation? And so, and if it's not, then you have, and correct me if I'm wrong, and we got a whole wall of people that would know up there and some in the audience here, you have the opportunity to be able to basically stop that flow and take 100% of that to fill your water right. Is that not correct? And so I guess my question is, if they're up there pulling your boards out, are they saying that you're taking more than what you're allocated, or are they committing a crime, basically, according to state water law, and taking your water right or removing something on your property? So that's, I guess, what I'm trying to understand. And I see Dave Schroeder is up on there, and maybe he could even help me understand a little bit as my local guy. But I mean, if you got folks up there pulling and doing damage to your equipment, but you have the right to take that amount of water, unless you're restricting more water than what you're entitled to, I would have to believe the Board of Control would be there to take care of that for you, because that's their responsibility. Because if I'm taking too much, they can shut my pumps off or tell me to shut them down. So
I'd love to hear the answer to this question. And like you say, there's people that understand this a lot greater than I do. From a practical matter, if I have the senior right, and if I'm taking exactly my adjudicated right, and someone's pulling my boards and playing with my head gates,
and I have 9 ditches. It's a full-time job just following those neighbors around. I mean, and you know, I'm putting up hay and I'm doctoring cows and I have some other businesses that I'm dealing with. And I literally can't, it's not possible for me to follow that around. But I am interested to hear what the state engineer has to say. You did mention something that I was hesitant about bringing up, but I think it's in language that I'm going to present to you later today. It has been difficult for me. You mentioned crime. You said, well, that's crime. And I honestly believe that, you know, destruction of property, destruction of a head gate, stealing your boards, petty theft, taking your dams, literally could be a crime. Having shoving matches on ditches. Again, I said we're a little bit lawless in Teton County because we don't have control. And when I talk to folks, the statute don't really speak to that in water law. And maybe I'm wrong, but I think that maybe you should consider that. And I'm going to propose some language for you. If someone's doing destruction, I think that besides the civil remedy, which again, state engineer tells me it's the right way, I think there ought to be a criminal provision so that, because sometimes civil takes years, hundreds of thousands of dollars, go to the Supreme Court.
Kelly, I'm going to interrupt you there. That's our third topic. And so we're going to give you some more time to lecture on that one. We need to stay on topic here. So Representative Nyman, I'm going to allow the state engineer's office to just take 1 minute and quickly answer the question that was presented.
Mr. Chairman, can I ask one that's going to fit into that?
Hold it. Is it complicated?
No, I don't
Okay,
think
then
so.
you
It
can
just
ask
needs
it.
answered because it goes back to exactly what Mr. Lockhart talked about. Does someone have a right to go on someone's private property if they think they've been damaged to pull boards? Because I'm kind of a private property rights guy. My deal is they got no business on my place pulling a board. Maybe Board of Control does, but I'm not sure what a landowner does next door to me. And I'd like the state engineer to answer that because I might go to jail because I really don't believe my neighbor's got the right to come on my place to regulate water he thinks I'm taking.
Director Gephardt, I'm not going to let you answer that question. If you can stay with us for another hour, we're going to be addressing that on a later topic. So I'm going to focus us back on our pond situation. Thank you, Mr. Lockhart, for your
Thank you, Mr.
testimony.
Chairman.
Terry, would you come forward, please?
Hi, my name's Terry Webb and it's green, so I think the button's already pushed,
You're
right? And I'm a landowner. I've been taking some notes, so some things that I would just like to bring up or things that I was wondering. One of the things that we noticed when we started having conversations with some of the Corps of Engineers, the state engineer's office, is some staffing issues of them being able to get down here as much. And I don't know if that's taken care of. So I'd just like to bring that up. One of the things that I was wondering about is, and concerned about, is that if I have a problem, and this is after the ponds are in and after a lot of these issues are taken, that there isn't, I have to have a lawyer for a lot of these things to be taken care of. It's too bad that we have to go that part, because some of these pond owners do have lots more money than us. And it just makes it so it's difficult for, even if we have the other rights, the water rights that have gone back longer. I am concerned about a lot of the control, there not being a lot of checking and a lot of control after the onset by the Fish and Game, by the DEQ. I'm concerned about that because I think later on that could be when a lot of the problems start happening. And if there's not, and that could probably be because of staffing issues and not having quite enough time. I am concerned about, it's okay to have a permit, even if there's enough water just for one day of the year. It's August now. We don't have the runoff. I'm concerned that all is okay in the 1st of June. There was enough water then, but now it's not. So I am concerned about the proof always being on the landowner. And I do have a question on that. Is that also or the one that is complaining? The proof has to be on the one that's complaining. Does it, even if that pond was never permitted or it didn't go through all of the things, is that true? That's a question I have for you. Do you know about that, Mr. Chair?
Director Gephardt, did you understand that question?
Did I not say that correct? Sorry.
You're okay. I'm just going to the expert.
I apologize. I did not understand the question. If you could repeat it, please.
Okay, back in my notes, I've been taking notes the whole time. A lot of the things have to be by the proof, even back to Kevin Payne. The proof has to come from the land, the one that is complaining. Let's say a pond goes in early and it affects me later on down the line. A lot of that proof has to come from me. I'm wondering if, even if that pond wasn't permitted or didn't jump through all of its hoops, like he was saying here, does all the proof have to come on me? I'm still not, I'm sorry. I'm still not saying that correctly.
If I understand your question correctly, you're asking that you're not getting your water and you have to prove that you're not getting your water. Is that correct? Is that what your
And all
question
the
is?
proof. Even if the guy that came in with the pond early, let's say he just came in or diverted the water, like for that 60 days that he was talking about, I'm concerned that I have to come up. Why can't they just turn off his water until he gets fully permitted and fully taken care of? Why do I have to come up with all the proof? Am I still not?
No, I
explaining myself?
think I
Sorry.
understand. I might have Kevin come up to help me try to answer this. But if you're a senior user and you're not being satisfied your water right, then you would call for regulation. And at that point, then Kevin or the superintendents and their folks would come out and make a determination that yes, you are not being satisfied your water. And then that would trigger them to go and perform the regulation. One thing that I will point out is that we do not have the authority to regulate until something triggers our authority. And that is a call from an injured landowner or injured water user, excuse me. And then that would trigger our authority to go in and regulate. And I don't know if that helps answer your question or if maybe Kevin has more to offer. I turn it over to him.
Kevin, go ahead.
Mr. Chairman, Brandon, I think you're exactly correct in how you stated that. And I think we need to be clear too on what that call for regulation would look like and what source is actually short. What water right is actually being injured by the pond that in this instance being on. And so that's one thing we need to look at. We do hear often of groundwater interference complaints, which is a little different than it would be under just a normal request for regulation. And so I guess that would be my difference there. And if I may also to clarify a little bit, when proof is talked about, when I was stating about proof, I was talking about our hydrographers going out and looking to make sure that the permit was built to the specs, and that's what we refer to as proof. But I think under maybe the question, it may be referred to where is the burden of proof to see if there's an injury, and I just want to make sure we're clarifying that.
Thank you. Thank you.
Thank you, Mr. Chairman. So help me understand this a little bit better then. I guess my understanding of it was that these are basically flow through facilities? Or are these actually places that they are building, locking, stopping ditches or adjudicated rights from getting their flow? Or are these designed to just basically flow through, fill and flow through and continue to go on? Basically a wide spot in the ditch, for lack of a better description. Or are there actually situations or instances where they're actually capturing, stopping, blocking folks downstream that have a prior right from getting their flow that they're
Mr.
able
Chairman,
to proceed.
Representative Nyman, I think it's all over the board, and it depends on the area you're in, and it could be any number of situations. And we treat them by a case basis. And that's why one of the reasons we like to see a request for regulation is for we know where to go look, what water right is injured and who would be above it that would be junior priorities that could be affecting that water right. So that is certainly one thing in it, and we have to look at it case by case.
One more,
Thank you, Kevin. Ms. Webb, do you have another comment?
one last thing, then I'll be done. In my notes, I have that they were trying to determine, you asked, Chairman, you asked how many permits we had per year by state. They weren't sure. Then we asked Kevin, he said like 100 within Lincoln County. And my concern is the DEQ, like when Jennifer talked, she only talked about 9 permits coming through. So I got lost throughout the state. So I got lost with Lincoln County's 100 permits and her only having 9 permits. What happened to the 91? Are we not coming together? I'm
That's a
just
good
looking at my
question.
notes and I'm
We'll-
done.
We'll clarify that for you. Tell me again how many permits you've seen in Lincoln County in this last year?
So, Mr. Chairman, I had quoted 100 and it's a very brief estimate and it could change, year to year is certainly different. But that quote was also not within Lincoln County. That was within my division, Water Division 4, which would
Okay.
be a quarter of the state of Wyoming.
And you did say that.
Very good. So Ms. Webb, the difference is DEQ, Jennifer, sure I say this right. DEQ works in conjunction with the Corps of Engineers, and they only get involved if there's wetlands or if you're constructing a structure in a stream or river. So on my dry pasture, I can build a pond and get a permit through the state engineer's office only. They would never see it. So that's the difference between the numbers.
Okay,
A pond is not in a wetland environment.
thank you. Thank you.
All right.
Thank you for coming. Appreciate it. Thanks for giving me time.
Thank you for your comments. Anyone else would like to make comments? Okay. Thank you. Oh, there's one more. Come on up. You just about hesitated too long. I'm glad you got your.
Thank you, Mr. Chair. Carlin Gerard, I'm the Executive Director of the Teton Conservation District. And I just wanted to shed a little light. We brought that map to give a scale to which ponds have been developed in Teton County. We've talked about irrigation quite a bit, but there really is a scale of pond development in Teton County that's quite remarkable. And I just wanted to shed some light on that. So in some cases, we have spring creeks, some of which are class 1 waters, that if I were to have, and maybe even Senator Guru, go out there and try to find that spring creek at this point in time, it would be virtually impossible because the landscape of surface water has been altered to such an extent. We're talking about irrigation water that is now been reconstructed to serve as a surface water channel, looks just like a stream. Wells that are pumping multiple CFS being discharged into surface waters that look like streams, ponds that have multiple well inputs and multiple outfalls that all come together to form a system of surface water that is so complex from the perspective of just understanding where it is, what it is, let alone where your impacts are coming from. Some of these are impaired water bodies that we're trying to address. And I just wanted to just shed that light as well, because it's the scale that I'm talking about, I believe, is at the extreme end of what's possible. But I just think it is important to kind of consider that when you have a lot of resources available to move a lot of dirt and develop a lot of water, you can develop a system by which I think even just the regulation of that water becomes extremely challenging, just because it becomes such a complex system of surface water. And I just, that wasn't something we touched on today. And I understand it's at that 99 percentile, but it is something that happens now quite regularly in Teton County.
Well, thank you for coming up. We passed your associate too quickly this afternoon, didn't we? How many ponds do you estimate is in Teton County? or 1,300 ponds.
And that's in a very small private land area. Just considering how much the land area is actually, in private land in Teton County. So significant amount. And part of that has to do with the development of a pad for development of a home, excavating an area that then becomes a pond. It's for a while there, it was kind of 1 and 1. You build a home and you build a driveway by, it just kind of is one process for developing a lot. It's changed quite a bit recently.
So in your estimation, in your experience, would it have been helpful to have had an agency such as DEQ permitting these ponds so that you had a little better control over where and when?
Mr. Chairman, that's a wonderful question. And I would say at some point in the past, yes. This is one of those unique situations where I think Teton County has taken it upon themselves to try to develop a scheme within their land development regulations to begin to mitigate some of these impacts due to the scale at which it's progressed. But I do think it's similar in nature to what we've heard here with regard to somewhat of an ability to say no. But they are starting to come up with a scheme to say how. And that is to address concerns like we've heard today, things like water quality, temperature concerns. There's tools at our disposal to make sure that water is being drawn, for instance, from the bottom of a pond. Things like not building ponds directly adjacent to developed areas that have septic systems and fertilized areas, understanding that if you're just building a surface water system into these types of settings, you're creating a potential source for contamination that then could be just discharging to these water bodies that are natural. So they have come up with a scheme to address some of these things at the county level. But I think it's a wonderful conversation because I do think that, and I've had conversations with some of these entities on this very topic, and I really appreciate your time and thought on it, because I don't think the way that we're doing is necessarily the right way. It's just the way that we've defaulted to some extent. Yeah.
All right. Thank you very much. Any questions? Tim.
Thank you, Mr. Chairman. Can you fill me in? Your cohort earlier said that there was an individual that turned his water on, and it was 35 days later he got the water to him because all these ponds and stuff. Does he have a ditch? Are these people tapping into his ditch or his conveyance? Would you feel that like a foreign concept to me? Can you fill me in, please?
Of course, Chairman, Senator French. Yeah, so and there's more than one example, certainly in Teton County of that scenario that was described earlier today. The entire valley bottom in Teton County is coarse gravel cobble alluvium. And so it subs very, very easily. You could run water all day long and never see that water pool in many areas of the valley floor. as a result of that, a nice ditch that's well maintained and lined, can carry water quite well. But if you start building on-channel ponds in those ditches, which has happened extensively throughout Teton County, you can get a scenario. It was described earlier. Are people blocking the ends of these ponds? Effectively, by digging a hole in some of these ditches, you are blocking the outfall until that groundwater stands all the way up to the point at which it discharges over the end. And there's times when there's maybe a dozen ponds that has to happen before you reach the end of the line on those ditches.
Follow up, Mr. Chairman.
Go ahead.
So they're illegally digging into this individual's ditch that is supposed to travel down to his ranch, whatever. They're tapping into that water that comes, and then until that fills up that cobblestone, whatever. So they're illegally doing that? Do they have permits to? They don't have permits to take his water. I mean, I'm still lost here.
Mr. Chairman, Senator French, most of those are very likely permitted ponds. And there's people in this room who are so much more intimately familiar with the system. I hesitate to comment in too much detail, but no, I think it's that scenario that we've been hearing about where as a downstream, Mr. Lockhart said, as a downstream water right holder, you get a letter that says there's a on-channel pond that's going to be developed. And he says, no, thank you. But in the end, that pond gets developed anyways. And so I think many of these are permitted ponds, actually. Yeah. And it's a challenging thing to manage. Once it's put into place, it's just a very hard issue to remedy, I think. And in some cases, it's resulted in water rights that are really no longer viable. It really has compromised the ability to have irrigable lands at the ends of some of these ditch systems.
Very good. Any other questions? Thank you very much for your comments.
Thank you. It's funny to hear a conversation about ponds. Feels like a Teton County issue in a big way, but I do think it's relevant to the rest of the state at this point. So thank you.
It certainly is. For the longest time, we watched Teton County just carrying on, and now the rest of the state is starting to experience many, many impacts similar to Teton County, and so we're paying a lot more attention. We apologize for not paying attention a decade ago to you. Okay. Committee, it's back to us. There was no more comments. Anyone else? Oh, Mr. Linford, please come forward.
Thank you, Mr. Chairman. Different than this morning, I'm just representing myself as a landowner. 2 comments on ponds I think need to be considered. First off, I agreed with the comment earlier that I believe the pond owners feel like they have the right to fill their ponds. We've been watering our cows in a certain area for as long as I can remember, and our new neighbor, wonderful neighbor, built a large pond, and this winter we had no water in the creek to water the cows anymore. And as soon as we let him know, he was just like, oh, he was very helpful and shut off the water to his ponds and put some more water back in the creek and help the situation. And so I think there definitely needs to be some education to these people that are permitting ponds. The other comment I have is I do believe that it is affecting water quality. I'm probably a little older than I look maybe, but I live on Crow Creek, and when I was younger, we had no issues with moss and weeds growing in the creek. There's been a lot of ponds that have been constructed upstream in the last 20 years plus probably. And now we have those issues, which I think is warming the water, creating an environment for the moss to grow. And it's just moving on down, causing issues with irrigation, plugging rainbirds, things of that nature. And it's just the water in the creek itself is not as quality as it once was. So those are my 2 comments on ponds.
Thank you. One last call. Anyone else? All right, we're back to the committee. Representative Nyman.
I would, thank you, Mr. Chairman. I would have some questions for our state engineers and stuff, because I guess my question as I've listened to this conversation is there's a difference between a stream and a ditch that is designated to take care of adjudicated water rights that have a priority date and have already been set up. And so, and then some of these this discussion was that they're literally pulling water out of ditches, evidently. And that in and of itself would be regulated and mandated by the Board of Control. I mean, I would love to have a ditch flowing through me and just have the arbitrary idea that I can go and just take a backhoe and cut a hole in that thing and fill some water off to the side. But legally, I can't do that because that water is already used. It's designated for lands. That speaks to the issue of the gentleman that you were talking about that's 35 days out to see his water get to his fields that he has an adjudicated right to water because it has to fill up everybody else with a latter priority date before it can get to him. So that is a question I think that needs to be probably, and it probably is already taken care of in the statutes. Secondly, I guess my question is the difference between trying to divert water out of a live stream that has water rights that are attached to it would also be an issue that what I would think all of these would be statutorily been taken care of in the rights, because priority water rights and dates would trump this and would cause, an action on the part of the Board of Control to come in and say, hey, this user is not getting its right. You get a one-time fill. I've already had that long discussion with my district supervisor, is that you can get filled once, but you evidently under current law do not have the right to fill multiple times. And so that would be my question to the engineer's office. Am I missing something here? Otherwise, I mean, that water is designated. You can't just go and arbitrarily take it off if it's already got an adjudicated piece of property that it's destined to go to and it's being halted to fill a latter priority date pond.
So Representative Nyman, I'm going to quickly answer that so we can move past the water right issue. The answer is, if you're going to do anything with waters, whether it's a canal or a creek or anything, it has to go through the state engineer's office. They have to issue a permit for that. And you either have to transfer water rights or you have to file for a current date priority. But Wyoming water law provides that always first in time, first in line. And so if you're damaging some other water rights, they have the ability to call the state engineers and complain and have that regulated. So we're really not, the issue is not water rights. I think we've already got that addressed and it's in the statutes. The question is, are other pond issues not being evaluated and considered? And that's really what we're boiling down to is, do we need another state agency to be involved in order to make sure that other than water rights, because that's being well addressed now, other issues are being involved. I want to look to Representative Larson. Are you there, Representative Larson? Click your mute button for me, would you? Do you have ponds being constructed in Park County and Bighorn County?
Yes, Mr. Chairman. Yeah, we do.
And is there a perception there about challenges with ponds, or is it no big deal up in your part of the state?
Mr. Chairman, obviously, I think most of you know I work for the state engineer's office. My boss is sitting right there in the video. We do have quite a few ponds that get built. And like it was said before, we don't go out hunting these down. Usually somebody comes and complains and then we deal with them. As a hydrographer, that's what I was told to do.
Good, thank you.
So Mr.
members,
Chairman, sorry.
Yes, Representative Larson.
Mr. Chairman, as a ex-manager of a irrigation district, we didn't actually get involved with that sort of thing. Usually after it went past the head gate, then they did with the water what they were permitted for most of the time, but didn't get involved with it as an irrigation district that much.
Thank you, Representative. So, members, The question is, do we think this is an important issue that we need to continue with and ask Abigail to look in the statutes and our neighboring states and determine if there is some proposed legislation that we could imply to help this concern over ponds? Senator Grew.
Thank you, Mr. Chairman. Yeah, just a couple of comments. To our friends in Lincoln County who asked us to take this issue up, as a representative or senator now from Teton County and a former county commissioner, welcome to our world. As we've heard today, I think you're absolutely right. I think that we do need to take a look at this. Now, I know that we value our private property rights. We value not having less government rather than more. And we all know that, and those are values that we all hold. The issue is, in my view, and I've seen it firsthand, is that in trying to do that, you get to a point, and I don't know if it was 800, 1100 or 1400 ponds ago that when this happened, but we got to a point where, and you heard, my friend Mr. Lockhart, and you heard the folks from the district say, we have issues, and I think we have more issues now than, and I think the folks from the conservation district are bringing up what I think are the real core issues of this is water quality. At the end of the day, while we need to address people pulling out tops of head gates and things like that, and we need to do that. But this water quality issue, at the end of the day, the first gentleman who spoke, Mr. Broder, I would say at the end of the day, making sure that you have adequate water quality. And I think we're losing that in Teton County. And I think that it's going to be this group's going to be looking at a lot of money for studies about water quality especially in the southern part of our county. And I think there might be, when we peel the onion back, we may look at these ponds and some of the other things that have happened there as a core issue. So I think it's something that you're right to be asking about. And I think that, we have tried, as it said in our land use regulations, to do it. I don't think that's necessarily, I'd like to think that the government closest to the people can handle this, but when you're talking about these layers of water rights and all that, I think it's going to have to be at the state level. I think that it seems like from what I've heard today that, we filed for permits to approve them. We want to approve them. That's what we're doing. I think we need another layer here. I think we need to look at a bigger picture. And I don't relish that to say that, because that does involve maybe some more staffing. Maybe that does involve more government. And as you all know, I know former appropriators sitting down there, couple that, we get a lot of comments when we start adding employees, a lot of them, and, folks don't like it. So this is where this balance comes in about staffing issues and all that. So I think we need to take a good hard look at this. I really do. And I'd like to see us try to come up with something, maybe a couple of first steps, have the folks from have the folks at the state here, Mr. Kephart and some of his folks, and the folks from the DEQ, and maybe weigh in on it and come in and say, what are some proposals that we could look at to maybe one more layer, just to say, when you're coming in for that pond, maybe there are some other things to look at. What's happening around globally in the area? Are there more? How many applications have there been? How many applications are coming down the pipe? As it was stated testimony, folks, they want to have their pond. They want to look at their reflection. That's fine. We saw it today on the tour. But, when do you get to a point? Where's that point where we start to tip into, when those folks throw larvicide in those ponds to keep the mosquitoes down, when they start doing other things to, regulate the water and the temperatures go up and the algae starts to grow, or maybe other chemicals are put into those ponds, and then that leaches out into groundwater and into other streams. What are the effects? I think we need to know. Thank you, Mr. Chairman.
Thank you. Senator.
I think it's clear we need to go there, and I'm in agreement with Senator Grew, but I also think we need to go a bit of a step further in some of them. Some of it may affect water rights. I think Representative Nyman hit a point that to me is unbelievably pertinent. There's a big difference between diverting out of a stream and diverting out of a ditch that somebody owns. And I think it's very appropriate for us to look at doing a law that says when you've got a ditch, because our ditches on our place are 1800s. And I can tell you, we've never had it happen, but I would have a heart attack if I drove up there and they had a backhoe in my ditch, diverting it to a side pond that the state engineer gave him a permit that says we can't really deny it because he's not really taking anything out of your ditch right now. And to me, my ditch is my property, and I think maybe it's appropriate that we say, look, if you've got a ditch, it's got an easement on it and registered, that they've got to come address the owner of the ditch before they do anything to it. It's kind of like me adding onto your house. Is I think I need to ask you before I put a bedroom on it. And I think some of these issues really need addressed. And then the other part I hit, and then I've had frustration with the engineer's office. These off-stream channels make a heck of a lot of water just disappear in our country, and there's no chance to get it back. And it's also civil to get them to go drain it to get them to you. If you're on a territorial right and you need water to your fields, then supposedly it's up to you to go to your neighbors. And the old saying, whiskey's for drinking and water's for fighting, really gets appropriate when you start trying to enforce your own water rights. So I do think we need to go some past water quality and look at some of what this thing had to say was the Constitution of real true beneficial use of the water. This will anger some people of the 1,500 ponds. It was set up to put it on the ground to produce things for the state of Wyoming, people and the state. And the ponds have a use, but it really wasn't the constitutional use that was set up with water. Water's property of the state, and it was set up to use it beneficially. And so I think this is going to be a very touchy subject on part of it, but I think it really needs addressed because ag's starting to take a back seat on some of this to where we're at, and ag's still our backbone here. So that's my 2 cents. I'm not sure how to get the bill drafts, but I like the water quality Senator Grew brought up, but I also think we need to figure out how we protect these old, sometimes century-old interests that they don't have to defend themselves. And often they don't have the ability to defend themselves, sadly. So how do we take care of that? Thank you.
Thank you, Senator Driscoll. Good. And I think you're right. You would have a heart attack if you saw an excavator on your ditch. That would not be good. Senator French?
I'm a bit reluctant to add another layer of bureaucracy and involve another agency. I do agree with Senator Guru and Senator Driscoll that I'd like to see the state engineer's office, when they permit these things, bring to us, the committee, a broader, a more expanded look at these ponds, their effects, and what happens with all these ponds. You know, I think I'd rather look at that before we start writing legislation. I think we need a little broader look at it before we go there. I know it's becoming an issue, but each layer of government or agents that you add, the more it costs the individual. There are more money involved, attorneys involved, whatever. But I think we just need a bunch more information from the state engineer's office to fully look at this thing through. You know, it's obvious there's problems, but that's my 2 cents.
Very good, Senator French. I'm going to propose, in the interest of time, a proposal and see if I can get a motion attached to it. I think the general consensus is this is an area of concern and we'd like to address it further. So I'd suggest that we recommend to our LSO, Legislative Service Office, staff to look at neighboring states, the laws that they have in place and how they handle the situation, and report back to us ways that we might improve the situation without getting carried away and creating a new agency on the issue. But to continue the process and look into this further and report back to us at our next meeting. How do you feel about that? Is there a motion to that effect?
So move, Mr. Chairman.
Thank you, senators. All right, we have a motion and a second. All in favor, please indicate by raising your hand. All opposed, please indicate. Very good. That motion passed. Abigail, do you have any questions about that motion?
Mr. Chairman, I think I'm good, especially with the Zoom recording.
Very good. All right. Thanks, ladies and gentlemen. And again, thanks to everyone that testified, particularly those that traveled such a great distance. We appreciate your time and effort. So we are going to move on to the next topic at 2:35. Water right issues associated with the development of lands within an irrigation district. Let me give you a little background with this topic. So a year ago, we had a look at the subdivision process and water rights. And we determined that there were developers that were coming in to the state of Wyoming and developing lands and would file for water rights, which was required, water right adjustments, and they would get their final plat and proceed with their subdivision, sell their lots, and never follow through with their water right expectations. And so that creates what we call an orphan water right, just hanging out there because it was never completed and followed through on. And so we passed that legislation to require a developer to finalize his water rights before he finishes his subdivision, is allowed to sell lots. So with that, I was visiting with the governor when he signed that into law, and he said to me, Representative Simpson, what about the application when a subdivider, let's say, for example, takes a 40-acre parcel, he's inside of an irrigation district, they have debt service and everybody's paying their annual payments to cover the debt. And all of a sudden this developer makes the decision, he has 5 options to do with his water rights. One of the options is to abandon the water right completely and just do away with it and leave it alone. Well, the challenge with doing that is that leaves the irrigation district holding the bag. They've still got a monthly debt service they have to pay to whoever they borrowed the money from to make the improvements they've made. And so the governor asked us to address that. Is it a challenge? Is it happening out there that developers are making the choice to abandon their water rights and leaving the irrigation district high and dry with no more future assessments? And so we have joining us State Engineer Gephardt, and we also have representative from Deaver and the Deaver Irrigation District and the Shoshone Irrigation District, and they're going, oh no. Is Jerry here in person? Jerry, welcome. You drove all the way down from Powell. Is that the Powell area? All the way from Montana. Wonderful. Now, Trent Reed I believe, is going to be online. Yep, there he is. And he's from the Shoshone Irrigation District. So we're going to turn first to State Engineer Gephardt. Director, again, welcome to our meeting. Thanks for taking time for us. What do you have to provide for this? Is this a water right issue? Do you guys ever get involved in this?
Mr. Chairman, I don't know that it is a water right issue, from at least from what I understand of the previous conversations. I also had the same question from the governor when the bill passed, and I really didn't see that we had a role in that at that time, but certainly here to answer any questions if it does pertain to water rights or our authorities. But from what I have seen, I don't know that we have an issue or a purview over this right now.
Okay, thank you, Director. Yes. Representative Nyman.
Thank you, Mr. Chairman. Just one curiosity, Mr. Chairman, to Director Gephardt. Is it possible that in this, that when these water rights are orphaned or basically abandoned, could other downstream users apply for those white rights of that water out of state or below it? Being as they know that that was a former amount, adjudicated amount to a specific area, so many gallons CFS. If they're no longer being used, could other stakeholders downstream apply for and get those waters? And my only concern would be an out-of-state user would do some checking and find out there's been quite a bit of water that has been abandoned and is no longer being applied to certain properties. Can they apply for and move those and take those water rights and remove that water from the state?
Director Gephardt.
Thank you, Mr. Chairman and Representative Nyman. I will answer that, and I will allow my superintendents to correct me if I'm wrong. But if those water rights are abandoned, the priority date of that is also abandoned. So any new application would be for a present day water right. And that would be the case whether they knew that water was abandoned or not. So it would only be for a current day water right. So essentially any abandoned water becomes system water, and then it becomes part of the system, and the water use is under the priority of doctrine and doctrine of priority, excuse me. And you couldn't go chase that existing water right, is what I'm saying. You couldn't get the priority date of the water right that was abandoned.
Thank you, Director. Jerry, would you come forward, please? Take a place there. So we've asked a couple irrigation district people to share with us if they've had this experience before, that are developers abandoning and walking away and leaving you with the debt service.
Yes, Mr. Chairman. In particular, on our Shoshone project up in the northwest part of the state, the development that's occurring immediately outside of the towns are starting to see cornfields turned into parking lots. And that's where we're seeing the abandonment of the water rights, or the requests for the abandonment of the water rights. Mr. Chairman, my district is 15,500 districts. I'm just below Trent. Trent is my best friend because he sends me my water, type of thing. But he's seeing the actual development of these lands where it's attractive and the property values are attractive for subdividing these smaller farms, say a 40 or an 80, turning them into smaller farms, and they have water on them. And yes, they are building a few ponds here and there, type of a thing. Our district encourages people to build a small stock pond rather than take their water all summer long. Put it in there, fill up your pond, shut your water off. That's just a side note type of thing. We're seeing in my district, I have a total of about 45 actual subdivisions, but none of them incorporate any type of industrial or municipal usage. There, like Trent's district and Shoshone Irrigation District is seeing, they're becoming parking lots, they're becoming industrial parks. They really have no use for this water anymore. And what we're faced with as a district, Mr. Chairman, is that it's not so easy to just transfer those water rights downstream or give them to anybody else that might necessarily want them. In particular for us as the Shoshone project, we're reclamation projects, and we are maxed out on the amount of acres that have been approved otherwise to say this is irrigable ground. This ground, you can go ahead and take this water that's adjudicated and put it on it. We would have to study ground, maybe even above the canal systems, and see if we're capable of moving water, say to a pivot system or otherwise. We have ground around us. We just don't have a lot of this ground within the actual borders of our districts because we are federal projects. It's not that easy. Now, the other side is, and I fully understand what the House Bill 002 is trying to do is that we're also faced with the law actually says that you don't use that water for 5 years, you're supposed to give it up. Well, for us as a project, a little district like mine, 15,000 acres, we have to have that revenue. That's a basic question up front. Like you mentioned, Mr. Chairman, that's how we pay off our debt and our construction debt. Back in the 90s, our projects all, Shoshone, Willwood, I believe there's someone from Heart Mountain here. I saw their pickup somewhere. We all went into an R&B program. We owe millions of dollars to the Bureau of Reclamation that needs to be paid back. And when we see this development going on, it's lost revenue for us. If we were to just say, yeah, I'd love to be able to say to these landowners, I don't want to deal with you anymore. I'll just shut you off. I need your money in order to operate this district and pay back the operational costs, et cetera, and our debt. One other thing to keep in mind in consideration of this House bill is that as federal projects, now I'm not suggesting that we don't have mechanisms in which we can reclassify the ground, but we all have contracts which actually state that you will provide water to these parcels and these tracts of land. And there's a few other layers to consider in terms of like, okay, we are contracted with the federal government to provide water to that land, whether you want to subdivide it or not. So keep that in mind. Now, I'm not suggesting by any means we want to involve the Bureau of Reclamation in any of this. I know that's not what I'm saying at all, Mr. Chairman. But I want to be very blunt and very honest as well. There was some conversation about the layers and bureaucracy and so on and so forth. I probably already know the question or the answer to this question. Rather, the state engineer's office wants to, in any way whatsoever, be involved in subdivision permitting and processes, et cetera. Obviously, if someone doesn't use that water right for 5 years because they paved over that coal or that cornfield, something's got to be done with those. Otherwise, we're ignoring the law that those now you're supposed to use it or you lose it type of a thing. Yes, there is a process where you can change the place and use, but does that necessarily fit in with everybody's district, such as mine? The House bill, I did read through it. I fully understand the intentions. I do think I would ask you to pump the brakes a little bit in trying to find a one-size-fits-all law for every district. Our projects, Shoshone's project, we have some specific rules. You follow these rules, you get your water. We're not junior, senior water right, anything. Our water's stored, it's adjudicated. We're the appropriators of the water. And we have our own policies in regards to actual subdivisions. Mr. Chairman, I'm going to tell you right now, and I'm going to be very honest and straight faced. Yes, we try to get along with planning and zoning. And I'm being honest, we do. But they hate it when they say we've got something coming in to planning and zoning, and it involves water. Everybody would love to have a law, including irrigation districts and in particular, Mr. Chairman, planning and zoning that has a law that they can default to and say that these laws are the state laws, you will follow them. But I think that the ultimate law would probably be about as thick as that book in total when it took in every potential situation, every districts, or they're striking the word districts and using entities now, every possibility and circumstance. This is how it's covered by state law. I would say slow down and find a way to address the 5-year issue. You don't use that water within 5 years. Is there an abandonment issue there before there's an approval? Planning and zoning, where we are working with them, don't get me wrong, but my district, I work with 2 different counties. I work with Park County, and my district is also in Bighorn County. And believe it or not, I actually deliver water to a small section of the state of Montana. So I got all kinds of entities that I might end up having to deal with in the future. They would like to have some sort of default. They just want to say, and when I say they, I mean planning and zoning. These are the rules, you follow them. We're trying to say, please don't approve these subdivisions without involving us. And to some degree, maybe we're saying, get our approval before you do this, because we're unique, that we are required to provide water to these districts. We are required to abide by our contracts, and we all have policies. That's just the crux of the whole problem, is that if we had one state law that covered everything, but that every county has their own planning and zoning rules. I don't know the answer to that. I would probably very selfishly, and there may be some other entities that may not agree with me. I think it should just default right back to the districts or the entities themselves and say, you're not going to be approved as a subdivision until we say so. Because now there's some language in there that says provide a plan and don't get any burden on us and then sign off type of a thing. But ultimately, we're still under a contract to provide that water. Now, until they can say, yes, you're going to still get money from here. We can move the water rights there, these types of things. I'd hate to see a streamlined default process where the districts, speaking for the districts such as ourselves, that we're kind of at the mercy of just the county laws and then in the state law that's broadly applied, Mr. Chairman. So that's what I'm kind of here today, is just kind of keep this in mind. I don't know. I don't want to suggest anybody say that the state shouldn't be involved. I think you're going to have to be involved, and the state engineer is going to have to be, and we're talking about water. But I would please ask that we, in consideration of that, make sure the districts are still have a say and a place at the table when it comes
Thank
to
you,
that.
Jerry. And the bill you referenced was passed into law, and so you definitely have a place at the table. So the question at hand is, if a large store in your district built a big building and a huge parking lot, and they came to you and said, we don't want to pay our fees anymore, our water bill to the district because we don't need the water. Have you had that application ever happen before, and what do you do with it?
My district hasn't had that. Mr. Reed probably has had that. He has hundreds of subdivisions.
We're going to talk to him next.
But quite literally, unless they went through our own process of reclassification, saying you're going to move our classification off, and then obviously the state water rights, the short answer would be that you may not want to pay it. You've come in and done this without going through some sort of process. You're still going to be assessed. You're still on the assessment rolls we provide to the county commissioners. And until these other processes of ours are changed, you will be taxed until such time.
So you would handle it internally. Very good. Does anyone have any questions for Jerry? Senator French.
Just a comment. And I hope this didn't make you too mad, but I'm very reluctant to have the irrigation districts be the final say and saying, no, we don't want this subdivision, because irrigation districts and subdivisions are kind of on a polar opposites. They're a real pain in the rear. I mean, the Heart Mountain Irrigation District, which I'm a part of, and Representative Larson used to be the manager for us. There are a lot of subdivisions, but I gotta be careful here. The boards often despise subdivisions because they're real, and you understand where I'm going here.
Yes, sir, I do.
And you have a subdivision, 100-acre farms chopped up into whatever, 20 lots, 50 lots, whatever. And then every one of them want water on Saturday morning. So when they don't get it on Saturday morning, because they have jobs or whatever, and then that's the only time they can really irrigate, then they complain, they start calling the district office and saying, just raising heck, instead of, the irrigation districts, they have an out. There's water masters for these subdivisions. Once it goes over the weir blade, the district is responsible for delivering water. And once it falls over the weir blade, so it's kind of out of their hands.
Correct.
But they get all the criticism instead of, them saying, look, talk to your water master. He's the one that's supposed to divvy up for 20 people during the week. And then dry years, and maybe you get 2.5 feet going over the weir blade, divided up between 20, 40 people. It's an issue, big time. And I get that. And the irrigation districts hear it big time. So I understand that, but I just don't think they should have a final say on whether a subdivision's approved or not. I mean, as a former county commissioner, I dealt with a million subdivisions in Park County, and they were real issues. And everybody's got a dog in the fight. The irrigation districts, I get their point of view, but also, hate to say this, but there's a need for lots out in the country. Not everybody wants that's, like Teton County, Park County's growing like crazy. They're coming in. They don't all want to live in town, Powell or Cody. They want to be out in the country and have 2 acres, 5 acres, so they can have a horse or a 4-H project for the kid. So it's something that's a necessary part of things. But like Park County, the commissioners are the final say in the subdivision process. And we have our planning department that goes through it and then makes recommendations up the line. And they're supposed to talk to the irrigation districts. Hey, give us your input. You're not the final say, but please give us your input so we can try to deal with that, in a manner. But I'm just reluctant to have the irrigation districts be a final say on that, just because of the fact that they don't play well together, and
I know.
Delivering water and to a 100-acre farm versus delivering water to 50 people on 100 acres, it's a real challenge.
Right. Mr. Chairman, if you don't mind, just to clarify just a little bit of that. Yes, we were self-reliant, have been for 120 years, and we are controlling our own destiny, and that's how our board tends to be. I would at least just ask that before any abandonment of water rights take place. Now, that's a very general, broad discussion, that the irrigation districts do have something to say about that. I mean, no, do I want to say no to someone who's going to make millions of dollars from developing this land that's bringing tax revenue and jobs into our districts. But the abandonment of the water rights is what's at issue for us, because that's our bread and butter.
Very good. And Jerry, that is in place. Senator French.
Just a quick follow-up. I would agree that you really do need to be involved on that issue.
Thank you.
So for the folks in the audience, that currently the state statutes provide and protect against that. They indicate that a developer has to be communicating with the irrigation district, and the irrigation district gets to provide input. However, the ultimate say is back with the planning and zoning department. If they comply with the irrigation district's requests, then they are able to proceed with their subdivision. So I think the state statutes have a good, comfortable balance there between the entities. So we're going to move on. Jerry, did you have any final comment?
I'll just thank you for your time and your consideration. And thank you, Mr. Chairman.
Thank you for coming all the way down. Welcome back to Star Valley.
Yeah, thank you very much.
Good to have you join us. Trent, are you there?
Yes, can you guys hear me okay?
We can hear you fine. Shouldn't you be outside somewhere running a ditch bank or something?
We've been dealing with underground drains. This is one of the issues we have with progress, I guess you say. So
underground drains, that's not on our topic. So So we're going to pass on that issue.
Yeah.
You can elaborate on another day. So Trent, what our question for you is, when you have developers that develop land and choose to abandon their water rights, how do you handle the fact that they've been paying into your corporate debt and now they're planning to leave and leave you high and dry?
So right now, currently the way things are set up, if a developer so chooses to remove those water rights, basically within that 5-year period, they either need to find a place for those water rights, or we will help them find a place for those water rights. Until then, they have to pay that assessment until it is properly, the new home is found for it, essentially. We do have some of these that, we're coming up on that 5-year period. We're working on trying to find some areas for that, because just like Jerry said, that is our revenue source. That's what pays for our operations and maintenance. That's what pays for our construction. That's basically how we survive. And those margins are getting tighter and tighter all the time. So we definitely don't want to see those water rights, move or abandon, because that is what we make them. Well, that's how we operate off of. So I try to kind of deter people from doing that. Usually a lot of times, you bring up the fact that, you got to pay an engineer to survey them, so then it gets petitioned and everything else. Usually that cost is enough to deter them. But if you got a 100-acre field that's got 30, 40 lots on there, that's not going to be a deterrent for those guys. I mean, it's, $5,000, $6,000 or whatever it is to have an engineer go on and survey these lots and have the water rights removed off there. But the abandonment issue is a very real concern. I think right now we got roughly about 300 acres that's in our pool, essentially, that we need to find homes for. So some of them are coming up on their 5-year date. We're working on, we got some different areas where we could put some potential water rights on, and so we're working with landowners there, looking at doing like a mass transfer, with that, and kind of split the cost up, amongst all the people who want these water rights. But it's got to be able to work within our system. There are certain areas, for example, on the Franny Canal, the water that Jerry gets, we can't put any more water rights on that. It's already struggling to assure that they get their water that they need to have, with our contract with them is, so it's a struggle to find places to put these. So I do try to deter them. And so far I've been pretty lucky. Since I've been here with the district, I've only had one developer that has actually gone in and removed his water rights. It is easier a lot of times just say, yep, go ahead, remove them. I don't have to deal with you then. But it's definitely it's one of those things you look at it and go, okay, well, that's X amount of thousands of dollars that's coming in that could be used towards operating. So we try to deter it. We try to find a place for them, but it is getting harder and harder because we got to operate within our confines, our district. We've talked about going north of lateral A, which is our very northmost subcanal. But it's a lot of that's on Bureau of Reclamation ground. It's in grazing leases, or it's on BLM ground. It's not something that happened very quick at this point. Plus, besides that, we'd probably more than likely have to expand the size of that subcanal to be able to deliver that water. So then you're talking about several $1 million more just in the expensive increase in the size of that lateral. So it's
wow, that was very helpful, Trent. Thank you. Senator French, you have a question?
Yeah, I'd ask Jerry and Trent to comment on maybe if somebody wants to abandon their water rights, would it be a good idea to say there's 15 years left on that R&B, loan, and it's X amount per acre, you need to pay your share for the next 15 years, because that's a debt that the district's got to pay back, whether you're using the water or not. Would you guys comment on that? Something like that? I know the developer might squawk, but at least the other irrigators wouldn't, the district wouldn't be holding the bag for that life, the rest of the life of those loans.
So Trent, as you answer that question, let me make sure I'm clear. So you're handling this situation of people that no longer want the water. You're dealing with it in your bylaws. You've got it written in there. You're going to pay for this water for 5 years, no matter whether you use it or not. And so Senator French's suggestion was, would you consider writing in your bylaws that as long as we have a debt service that you've participated in, then you have to just keep paying, period, or else a lump sum payout to get out of the district?
Mr. Commissioner, that conversation actually has come up before. It's kind of a mixed feeling, across the board with everybody. I do think that is a good idea, but trying to get people to go with that, I think it would be a challenge. But no, I think that's what really, if somebody wants to remove those water rights off their property, in my feelings anyways, is they should continue to pay out what that debt service is, whether they paid in a lump sum, they want to develop it, they want to remove those water rights, they write me a check for, whatever it is that would be owed on that ground. At that point, I would be fine with that to a certain degree. It's a bit of a double-edged sword, talking about the development side of it, but also you get in a watertight year, those water rights, that is our water that we can bring into our system. So we start, say we start doing this and we get a whole bunch of people all of a sudden that want to just say, nope, I'm done with this. I don't want to deal with the water anymore. And say I get 1,000 acres. Well, that's 1,000 acres of water that I'm not going to get in our system that potentially could be used for production agriculture, or whether it be these subdivisions. A lot of these guys, they got a 5-acre lot, they got a 3-acre pasture, they got a couple of horses, they got a couple of cows. Like Tim said, they got a 4-H run a fate project. And so I don't want to hurt them by all of a sudden having a bunch of these water rights removed. But I would not be opposed to the idea of a developer, if they want to do this, pay out that 15 years or whatever is left. I can't remember what it is. I think it is about 15 years it's left on that node. If they want to pay that debt service, by all means, I think I would be okay with that. But there is that concern of not having that water going into our system.
Thank you, Representative Nyman.
Thank you, Mr. Chairman. Just one quick question, just so I kind of understand a little bit more of the background on this. When the projects or the building that was done on these particular ditches, when you guys take out and you borrow this money, is there any kind of lien or anything placed on these properties that would be a responsibility that would say, hey, I'm a part of the district? Is there any attachment to the lands? Because I would think that would have to be taken care of if those lands are sold, and that would follow that, or they would be responsible to pay for whatever, share that they had in that project. And so I'm just curious, how do you guys do that? Just from my own understanding, when you do a project, do an upgrade or fix something and everybody is responsible, has so many acres under that ditch, is that debt attached to the property or somehow attached to the acres that are being irrigated? And would they follow that even if the hands were changed, and that debt would be basically a lien? And would they have to sign a waiver? You guys as a district would have to sign them a waiver to say, well, you're no longer responsible for that? Or is that a responsibility that that piece of property carries with it until that debt is met that they were responsible for?
Trent, do you understand that question?
I think I do. Right now, from my understanding, I guess, and granted, I'm still fairly new I guess within the last 5 years on this, and I'm definitely learning more all the time with this stuff. But my understanding is, that these R&B projects, those were a debt service to the irrigation districts. It is assessed out to the acreage, but that debt service is ultimately on the Shoshone project. So for me, it's a Garland, Garland Shoshone irrigation district, Heart Mountain, Willwood, Beaver. I mean, they all have had their own projects under these R&B, and so to my understanding, it is our debt. It's something I would like to look into, I guess, is if it is possible that, we have to make these guys pay that up before they would sell it or remove the water rights. I mean, we have people selling property, buying property all the time, but that debt should be attached to those acres. And so I don't know, Jerry, do you have any more on that? I guess
my experience is that when a district takes on a loan from a government entity, that loan is not pursued down to the individual properties and filed with the county clerks so that it represents a mortgage on the property. That just doesn't happen. So a person could walk away from an irrigation district and say, hey, I'm heading back to California. See ya. Here's my address. Don't mail me. And they could just walk and there would be no repercussions unless Trent's idea of incorporating that into our bylaws. But every district would have to do that. If it's not in the state statutes, every district would have to write it in their bylaws to protect themselves. Go ahead.
Thank you, Mr. Chairman. Well, it would just only make sense to me is if you're going to be a part of a project and this project is going to benefit you and you're going to take the increase or the income off of that, then why would anybody go and say, hey, we're just good enough guys and we're just going to do this. And if you walk away from it, we'll just absorb that debt.
I know. And that's the very reason we have this topic on the table right now is because the potential for a major property owner to walk away and leave a district hanging.
See, I think it needs to be attached
Mr.
to the
Speaker,
property that it's
Mr. Chairman.
Hold it. Who's talking?
Representative
Larson,
Larson.
go ahead.
Yes, thank you. I managed the Heart Mountain Irrigation District, like we said before, for 8 years. I do have a comment on this. I think the Bureau of Reclamation, when they initially built the dams and then the projects, they did put the assessment on the lands, and they will have to pay those off until those loans are paid off. I think the districts have the ability. Obviously, they're taxing these lands themselves instead of the county doing it. I think they have the ability to continue those taxations until they determine that they don't need to. There for quite a few years, the Bureau had it in their policy that if it was less than 40 acres, they weren't going to deliver water to those acres. They did change that. I don't know if that was in the late 70s or not, but there for a time, they said you will pay the assessment and you will not get water. But that has changed. So I think that the districts have the ability to keep taxing. And if they don't pay their assessment, then it will go to a sale at the county level. And it will be just like not paying your property tax. I do have a question for Trent, and I think I know the answer. I don't think the Garland district ever put into the bylaws that if you tried to abandon, you could ask to abandon these. But I know at Heart Mountain, they said you will pay $5,000 per acre, and that would carry hopefully into the future to pay the O&M and the payment on their loans. So I know Heart Mountain has that, I think, still on the books, and I would like to ask Trent and Jerry if they have that.
Representative Larson, we do not have that on the books. It is something we have talked about because I know you guys have done it, talking with previous manager Tyler Weckler up there, he did mention that is something they do. The problem that I see is, I would actually like to pursue this long-term, basically pay off, so if you got 5 acres, figure out, what that amount would be for that 15 years, whatever is left on that RMB. Just because that $5,000 really doesn't go very far in this day and age. If they're gonna they're gonna do this, they need to go ahead and pay off the rest for their acreage. And then at that point, I would have no opposition to them saying, okay, go ahead and remove them. But I want that, RMB paid off for those acres. It has been a conversation that we have talked about over the last year. Like I said, kind of got a split board on it right now. I think as we get more development up here, and it just keeps coming, I think we'll probably see more the board maybe switch towards agreeing with that. But we've done a few different things, too. I mean, we've kind of adopted that fee schedule, like Heart Mountain has and whatnot. And that was kind of a Shoshone project discussion on that. But, it's still the fee to remove them. We do not have it in our bylaws at this time currently.
Mr. Chairman, follow up.
Representative Larson, go ahead.
Thank you, Mr. Chairman. So have you had people try to abandon their water? Well, like maybe I should put this different. Do you have people not pay their assessment, and do you take them to the county level and force the issue?
Representative Larson, yes, we every year we always have somebody who we get a few, that they don't pay it, whether times are tight or they're just being stubborn and they don't see a need that they have to have it. And yeah, they go to the tax sale. And we've had a few that are so stubborn that they won't pay the $600 and end up losing their place. We've had a couple of them like that. It's like, man, Eliza, 18 months is the water law for this thing. They got 18 months to get that paid back. And that CP holder then has that opportunity to rightfully take ownership of that. And we've had a few of those that are very stubborn, and it's like, I can't believe you let it go for less than $1,000. And most of the time it's these guys, they got 1 acre, 2 acres, 3 acres. It's not your bigger guys, got some acres. It's these smaller landowners. But yeah, every year, we send a dozen or more, and we've had some years where we maybe had 1 or 2, but we always have a couple every year, it seems like. So
one more, Mr. Chairman, I'm sorry. So personally, do you think it's we have statutes in the law that deal with this type of situation, and abandonment of water rights is not happening on your district?
Trent, did you understand the question?
So right now I've only had 1 subdivision that has really been, well, they did file for the removal of water rights. Those essentially went into our pool that we have currently. Like I said, I've really deterred a lot of these guys from doing that, and most of them actually do want to still keep those water rights. But I've only had the 1 subdivision that has gone through the full process since I've been here. Before me, there was quite a few, and I kind of came in on the tail end of one of them. But the majority of everybody has opted to keep them and then go through with a water distribution plan, whether it be sprinkler irrigation or flood irrigation, and that sort of thing. So, but yeah, so far, most everybody has opted to keep their water rights attached.
Thank you, Trent.
Mr. Chairman, mine's
Senator.
probably more a little research ask is I'm unclear whether in statutes, how the attachments work. I know our district's BOR contracts are attached to the ground. They're clear there.
Mhm.
But our district, I know we've talked about it with our attorneys, whether we can actually do an attachment outside of BOR contract. And I think it'd be appropriate because I think the district should be able to, and they should be able to do them to individual accounts because we're the same. We're a little district and we had some people didn't pay them, and it really skyrockets your deal the next year when somebody, particularly if it's a major landowner, skips a year on taxes. And we've had some sold. I know Rep. Nyman knows, they get put up and well, they get sold. Someone buys them usually. So I guess to me, I think it's something we really do need to deal with. And possibly even to the point of looking at amending statutes a little so that we can carry on some of these within the districts, because we certainly don't want to extinguish water rights anywhere. And to me, even if it means we create a priority date that can stay with it as long as it stays within a district, I really believe that because we've argued that within our district. What happens when a prior right to a compact gets abandoned? Do you lose that prior right? Because we've got this big block of water where we're at, and does it move to another right that brings it into a prior right, or do you lose that prior right to another state? And legally, I think we can continue to hold those prior rights, and I don't think the state should ever abandon a right into a compact that they don't have to. I mean, if the feds say they do, but I think it's worth us looking at it to make sure that you don't have a right get abandoned, and then you lose that CFS, because most of these rivers, you've got X number of CFS prior to the compact. And if they go away, it means that the in-stream flow now has been transferred to another state.
Any other comments for Trent or Jerry? Any questions? Thank you, gentlemen. Appreciate your time and efforts to help us understand this issue. Thank you very much. All right, Director Gephardt, you're still with us? You've had a series of meetings this week. Are you still focusing on us?
I'm still awake, still hearing. Yes, sir.
You're doing great. So now after the testimony, are you thinking that this is either a district can handle this problem inside with their own bylaws? Or do you think it needs to be a statute that would be managed by the state engineer's office? Or what are your thoughts?
Mr. Chairman, I think that the law that was passed last year is the first attempt to address our biggest concern, and that is, I think we agree that we don't want to abandon these old historic water rights. We don't want to do that. On the same hand, it becomes a property right too, and that's what we have to weigh when these amendments come in front of us. So I think the existing law does a good job in providing opportunities and options to address this. And it's my understanding of what this topic is the assessments on either the land or the water, however that is assessed, and the ability of a district to continue to pay their debt service, whatever that is. So that portion I don't believe relates to the state engineer's office. I do think that the implementation of the bill last year partly involves us. The other thing that I'm listening, and I'm taking my state engineer hat off slightly, but it's my understanding that the two districts that testified today are Bureau of Reclamation districts. And I don't know how the same issues relate to private or individual districts either. So I'm not real sure on what their nuances may be when you start talking the assessments. But in short, to answer your question, Mr. Chairman, when we're talking assessments, I don't know that we have a role in assessments and boundaries.
Thank you, Director. So committee, The question at hand is, do we leave this issue of someone walking away from their assessments? Do we just leave it up to the districts and hopefully they'll write regulations in their bylaws to protect themselves? Or do we need a piece of legislation that, which we could just attach to our approved bill last year? It could be an easy paragraph that just simply says that if they abandon their water right, they still have to be accountable to the district. It could be a fairly easy amendment to the statutes. But we want to continue to add that. So that's the question at hand. Representative Nyman.
Thank you, Mr. Chairman. I guess my question would be to Trent then. I mean, Trent, is that what you would need? Or are you able to take care of what you're doing? Because according to your testimony, you are already in your ability to be able to do that. Now, your question is good. Do we want to leave it open that districts can put that in their own bylaws? But I mean, you're already doing it, Trent. But I mean, what is your thought? Do you think that we need to make that a blanket rule, or should that be something that's more of a local control issue in each one of the districts that you guys make that requirement of your cooperators?
I do think we do handle it within our own districts right now. But I could see it being a challenge down the road. So having this piece in there, I think it would definitely aid. I guess, I look at it this way. I mean, right now I'm averaging probably 2 to 3, subdivisions, whether it be simple to major subdivisions a week. And that's actually slowed down a little bit from what it was a year ago. But, the fact of the matter is I'm still getting, multiple subdivisions in a month that is coming across my desk. Like I said, so far I've been very fortunate. I have not had but one big subdivision that has asked to detach their water rights. Most of them I kind of deter them and they generally go ahead and decide to keep their water rights. But going down the road, I do believe it could be a very big issue. Not going to be able to, not everybody's going to be able to, not going to be able to deter everybody, I guess you could say. Simple fact of the matter, I mean, a lot of these people, they don't want to deal with irrigation. They don't want to deal with, having a water association. That's one thing that we do with our districts right now. Within our district, every subdivision has to have a water master. They have to have a water association agreement. They have to have an appointed water master, and they're responsible for scheduling everything. And you bring that up to some of these developers and they go, well, I don't want to deal with that. So what would it take for me to detach these? And, I tell them, what the engineering fee is going to be and everything else. And I tell them, once you remove those, chances of you ever getting them back pretty much slim to none. And that's usually enough of a deterrent that they don't move forward with the detachment. But that's not always going to be the case, especially down the road, I think, as we continue to see more people coming into the area. So, I don't know, Jerry, I guess what's your thoughts on this? I mean, is that something that you could see being an issue down the road?
Trent, I'm going to bring that back to my committee if I could.
Okay.
We just need a motion. Are we interested in a motion to direct LSO to draft up legislation on this issue or not? Would you state your motion, please?
Basically to have them draft on just have LSO go ahead and draft on the subject matter we've just been talking about, which is kind of broad. We went into 3 or 4 different subjects. So,
but the subject at hand is a proposed draft legislation would be to tweak the statutes. So they say if a developer abandons the water rights, he still has to be accountable for the debt service that the district, if he's in the district, he has to be accountable for the debt.
Correct,
service.
and allow the districts. So that was the further, was to allow the districts to be able to flesh that out with him. So
Okay, I have a motion and a second. So Abigail, you still with us?
Yes, I am, Mr. Chairman.
Abigail, are you clear on the motion?
Motion to draft bill to require if a developer abandons the water right within an irrigation district to still require them to be responsible for the debt service.
Now, and so if you provide us a draft for our next meeting, committee, what we'll need to do with that is determine what accountability is that. Does that mean they have to negotiate with the district? Does that mean they have to cash a district out for a 20-year debt service? Do they agree to, I mean, we're going to have to define that a little tighter as to what we mean by being held accountable. So if that's, then that's okay. We can talk about that after we see the proposed bill. Okay, I've got a motion and a second. We're ready to vote. All those in favor, please. raise their
Mr.
right
Chairman.
hand. Oops.
Mr.
Representative
Chairman.
Larson wants to
Yes, I'd like
interrupt with a question.
I don't have a question. I just want to comment. I really think that I am not excited about dealing with this. I really think our laws and statutes deal with this already. If you have someone not paying their assessment, even if the county is assessing those lands, I think there's ways to get those dollars. Just because somebody wants to abandon their water rights, I don't know if they can just go ahead and do it inside of an irrigation district. I'm going to be a no vote.
Representative Larson. So your point is that we don't need to create a new bill because you think that it's already addressed in a legal matter. I don't believe it's addressed in the statutes, but it may be addressed in other processes like contracts and bylaws.
Mr. Chairman, that is what I would say. I agree.
Okay, so I apologize for not providing debate on the bill, or Representative Larson. I just about said senator. That'd be, by the way, congratulations on your victory in the primaries. Any other debate? Any other discussion? Senator French.
My comment is I would just like to leave it in local hands, local control, like Representative Larson. I think they have the ability to address it. I'll be a no vote.
Okay. Any other comments?
I do, Mr. Chairman.
Senator.
I think at a bare minimum, we ought to search whether they have that authority to do that, because I'm not positive that they can attach on tax assessments legally. And to me, if they don't have that, we need to make sure they can. So, to me, if that's there and they've got that ability, maybe we don't need a bill. But if they don't have that ability, what we've said is you don't have that ability. And I think it needs to be really clear statutorily that they have the ability when you get in these districts to attach to the real estate, because that's the only teeth you've got. So maybe research alongside a bill, and if it's actually there, I agree, it's no big deal. If it's not there, they should have it.
Very good. So Senator Driscoll, you're still in favor of your motion to proceed with the draft bill, but you're also suggesting that keeps the door open for us to debate it again with some additional information to decide whether or not we like the bill or not. And we can throw it away next time if we're unsatisfied.
Yes, sir.
That's what your point is. Okay, any other discussion?
Mr. Chairman, one more. I'm sorry.
Representative Larson, go ahead.
Yes, I guess my other question is, when we say debt service, that's way different than O&M annual payments.
Yeah.
So debt service on Heart Mountain Irrigation District was probably around $2 an acre. Whereas the O&M and all the other probably add up to 25 or 28. So I just don't know if the bill is, unless you clarify that part, and can you go further if you went to court? I don't know. I can see where you could say they owe on the debt, but I'm not sure if that's what the irrigation districts want. I think they want the O&M payment.
Representative Larson, I would I would throw this out for consideration. Debt service is for the infrastructure that you've already agreed, everybody collectively agreed to take on a debt to build a new system. Operation and maintenance, if a person is abandoning their water rights and leaving town and there's no operation and maintenance for their piece of property, I would submit to you that that's probably something he could walk away from because he's not going to need any operation and maintenance anymore for his piece of property. Still leaves the irrigation district short, but at least it seems to be reasonable if that's how you divide it. But again, these are discussions. If we vote to do a draft bill, then that's information we'd want to certainly consider next time. Any other comments? Oh, Senator Simons, go ahead.
Thank you, Mr. Chairman. I just wanted us to consider and not forget that some of our, we call them irrigation districts, but there are associations and other instrumentalities that we use that are not actual districts. They don't assess their payments through the county clerk's office or use the local governments at all. So I think we would want to address them as well. Thank you, Mr. Chairman.
Thanks, Senator. And so the difference between a district versus an association or a water company would be that the association water company they probably don't have a big debt service because they probably can't borrow money. The district can borrow $10 million and are obligated to repay that. So I would submit there's kind of a natural break there, but I'm open for suggestions. Senator Simons.
Thank you, Mr. Chairman. Well, that's not the case here. Lingo Water Users has 11,802 acres, I think, under Pathfinder Irrigation, and they had a sizable bill in the Three Bricks project or the Pathfinder modification. They'll also see some bills from the latest canal breach that's here. So I think associations will see that as well. Some of them anyway, the larger ones.
Thank you. Lingle proved me incorrect. I apologize for my opinion there. Okay, any other comments? Okay, the motion is on the table to draft up proposed legislation that addresses, and the motion is that we address districts in their situation where they would have an abandoned water right and be left holding the bag for, at this point in time, it's debt service associated with that. That's the motion. And did I state that right? And then we'll go from there. All right. All those in favor, please indicate by the raise of the right hand. 3, 4, 5, it's 6 hands raised. All those opposed, please indicate by the raise of the right hand. 2, 6 to 2. So were you opposed? Opposed, 6 to 3. Okay, Abigail, please prepare a draft piece of legislation and additional information for us for our next meeting.
Sorry, just
Very good. We're right on our schedule for 3:35 to move on to our next subject. But however, we do need to take a break. Let's keep it brief. Let's do a 10-minute recess and we'll come back and finish our last item. I suspect our last item will take us only about 30 minutes. We'll wrap it up.
Yes.
Folks, let's come back to attention. Appreciate you. Abigail, feel free to get us logged back on live. Folks, I'm embarrassed to tell you as your chairman, I forgot a step in our last topic, and that was to allow public input. We voted on already, so unfortunately the public input can't change our minds. However, since it's a continuation project, I think it's appropriate. So I'm going to open the floor up and see if anyone wants to make a comment. So Lauren, come on forward.
Hello, thank you for opening this up. My name is Lauren Preston, and I represent sort of a group of companies in Bedford that's trying to become a district. And I think that, you know, while there are definitely advantages to having regulation on this front, one sort of potential shortcoming that I saw in the verbiage used was just talking about the debt. And I think that that might put us at a disadvantage for the future, in the sense that if I've got a 1 acre section of pipeline that has abandoned their water rights, or not 1 acre, 1 mile section of pipeline that has subdivided and abandoned their water rights, even if they've paid for the infrastructure that went into play while they were part of it, in 50 years, when I go to replace this pipeline, or even during the interim, the maintenance of that pipeline, I still need to maintain it. I still need to replace it, unless it's at the very, very end of that pipeline section or ditch section, or unless it, you know, it can be cut off and abandoned entirely. There's a lot of cost and maintenance that goes into the ongoing upkeep and eventual replacement. And I was just hoping, if you do bring this into conversation, you know, as far as amending any laws, I would like that to be taken into consideration, please. Thank you.
Thanks, Lauren. She brings a really good point, and we touched on that, and that is if we're going to propose a bill, we're going to have to quantify this whole thing about, because we want to protect the district, but on the same token, we don't want to make the district omnipotent that they can say, well, okay, you can abandon, it's only going to cost you $10 million, and literally take away the rights of the property owner. So we've got to find a way to quantify that in order to take a bill forward. Is there anyone else who would like to comment? Roland, please.
Roland Gardner again, Direct Creek Irrigation. Question, we've had this a little bit in our district. So if someone in my district wants to give up their water rights, they are still inside the district. And as a district board, we have the right to control that district boundary. And if someone's inside our district, then we assess them, whether they use the water or don't use the water, or whether they abandon that water or not. I think those are two separate issues, the district boundary and their water right. So I've always had the impression, and I've told people, and probably falsely, that you're inside the district, and because you bought land inside the district, then we're going to assess you that fee. And again, the county collects it, and it's a tax sale like everything else. So am I wrong? Is that different? If someone abandons those rights, can they force their way out of the district, I guess, is what they'd have to do.
I know that's a really good question, and that we're wrestling with that very thing. So do you have it very distinctly written in your bylaws? Do you have the authority to do that? Because it may just be a legal issue with the judge to make that. But if you don't have it written in your bylaws that you can continue to charge them even if they're not using the water, then I think you may be in a weaker position than
No, I think we need to address our bylaws to make that stronger. So
okay, very good. Thank you.
Thank you.
Anyone else? All right, thanks for those comments. Let's move on to our last topic of the day. And that is to review Supreme Court cases related to the conveyance of water across properties. Okay, this is an age-old problem. I have a ditch running cross-country through 20 different parcels of land. And guess what? The ditch has been there forever. And so there are not written easements, and they're not identified when you do a title search on the property. It's not an encumbrance on the property. And so we have this challenge. So I want to go in and maintain my ditch, but the property owner stops me and says, no, there's nothing in writing. Therefore, you're not going to maintain the ditch. And by the way, we're going to not allow any water in the ditch. I'm plowing it under. There's all kinds of scenarios that happen. And those of you involved in water companies and irrigation companies have lots of war stories on it. So the question here is, and we have a proposed bill that addresses, it doesn't fix the problem, but at least it brings it closer to resolution. And so we're going to talk about how ditch right-of-ways that are not recorded, how they're dealt with in the courts in historical cases. So Abigail and Director Gephardt. Abigail, let's start with you. And we won't bring up this bill quite yet. We're going to bring it forward and discuss it in about 10 minutes.
Mr. Chairman, did you want me to talk about the bill now, or you just want me to talk about prescriptive easements?
Oh, I just took the wind out of your sail. I called your name and then I told you I wasn't going to discuss the bill.
Happy to talk about other
We may
things.
not. It's getting late in the day. I'm not able to make those decisions very rapidly, am I? Okay, Abigail, let's pull up the bill and let's go through what you've written and prepared for us, and then we'll open it up for discussion from there.
Mr. Chairman, what I thought I would do is kind of set the stage give a background on prescriptive easements, the confines of kind of what this bill was drafted within, to kind of lay the land. You know, the committee requested to codify, basically, if you recall from the Board of Controls memo that was presented the last meeting, 4, 7, and 11. 4 dealt with how do you know if you have a prescriptive easement. 7 was how do you know how wide your prescriptive easement might be. And then 11 was access, in terms of how do I access my prescriptive easement, and if I try to stop someone from doing something that impacts it. So the difficulty with trying to codify this is under US and Wyoming Constitution, the state can't affect existing property rights. So if we're talking about this 100-year-old ditch that someone's claiming a prescriptive easement on, you're talking about an existing property right, both potentially with that easement and then potentially with, probably not even potentially, 100% with the servient estate, the land that easement crosses. And so the state can't change those property right owners' rights without paying for them. I suppose you could. That's when you would get into condemnation, and that would require a payment by the state. So I had to try and find a bill, draft a bill that might achieve some of the goals of this committee without actually impacting any landowner's property. So when we talk about prescriptive easements, it's case law in Wyoming in terms of to what controls, which is why these always go to court, and the judge has to look at the facts and kind of, do you have a prescriptive easement? Depends on whether what you're claiming aligns with the factors needed to establish a prescriptive easement. So in Wyoming, you have to have an adverse use, and it has to be sufficient to put an owner of the servient estate on notice of your claim, and it has to be continuous and uninterrupted for a period of 10 years. And the party claiming that prescriptive easement bears that burden of proof. So as the person claiming to own the ditch easement running across the property, you have to prove that. You don't there's not a default that this is yours because the ditch is there, but I will get into some presumptions. The court has traditionally also, prescriptive easements aren't favored in Wyoming. that burden of proof is in there because you are taking someone's property. So you have to actually come in and show that, no, you have a right to this property based on the existing law. So now I talked about two kind of different presumptions the Wyoming Supreme Court has used and acknowledged. And there's one, the presumption of adverse use. And that's the case where this is the one that in case law, the case cited in the Board of Control's document is saying, well, this has been here for 100 years. If you've been using it, there's kind of this presumption that yes, it's been adverse. But there's been other cases where in the situation that there's a presumption of permissive use. This would be where two landowners perhaps share a driveway. The court has said in those situations, and it's all fact dependent, but in those situations, there's a presumption that one landowner was just being really nice and friendly and decided to let his neighbor use his driveway, but there was not actually a grant of that land to the other neighbor. So there's two different ways. So my goal with this bill was to not change any property rights, but to hopefully codify the presumption that you can assume, that presumption of the adverse possession. So if you look at the bill draft, the outlines of this actually came from a Utah statute. I didn't pull it out of thin air. So you can find that if you're interested, but it says a prescriptive easement for a water conveyance may be established. Now this may be established. I'm trying to do nothing to affect the fact that you still have to go to court and then you still have to establish this, which I know is probably not the committee's intent, but unless a judge says you own this prescriptive easement because you've met the burden of proof with respect to the following elements, you don't own it. So you still have to go establish it. But if you establish that you as the water users used and maintained a water conveyance under a claim of right for a period of 10 years, during which that use has been continuous and uninterrupted, open and notorious, and adverse, that's how you would establish it. And then the B is where we're trying to codify the presumption if a water user establishes the continuous and uninterrupted and the open and notorious, there's a rebuttable presumption that it's been adverse. You've met that third element. So the rebuttable presumption is you're assumed to have met that third element unless the underlying landowner comes in and says, no, it was permissive, I let you use this. I can prove you don't meet this adverse element. So that was the intent, to at least put someone on notice in the statutes that there is a process for how you have to go establish this prescriptive easement. You can't actually just say, well, you have a ditch, it's been there, you own it. That would run afoul of the Constitution. Now, when the next following sections kind of try to address numbers 7 and 11 in the Board of Control's document. So if you have a prescriptive easement, if you've established it under that subsection A, then under B, C, little I, you may file a notice describing that easement in the office of the county clerk. And this would serve to help put landowners on notice when they purchase a piece of property that someone has established as prescriptive easement. It's not a recorded easement, but you have gone through the process of establishing it. And then this little II, this is where your prescriptive easement is bound to your historical use and what you originally had. So you can't put in statute, oh, you get 20 feet or you get, it really depends on what your historical use has been. And someone has to actually go in and prove that. But the statute would put on notice that if you've established a prescriptive easement, then you have the right to access, maintain, and repair the water conveyance located within the easement in accordance with the law. And then that in accordance with the law is in accordance with the rights that go along with the prescriptive easement in terms of your historical use and whatever you've been able to prove that you have a right to. Subsection D gives you a couple just definitions of terms of what a water conveyance is and what a water user is. And then subsection E was probably not specifically requested by the committee, but I worked with Vice Chairman Hicks to kind of follow along the lines of what Senator French had brought up at the last meeting regarding well, how do we just let people know that these are, when someone buys a piece of property and they're not familiar with ditches, running, water right, that they're used to riparian. How do you let them know that here's kind of some groundwork for what you might be buying into? And that would just be to require the Board of Control's document to be maintained and to be handed out in real estate transactions where these easements might be crossing, or ditches would be, water conveyances would be crossing, whether there's an easement, perhaps still to be determined, but that was the intent of subsection E. And then section 2 is the catch-all that nothing in this bill is intended to interfere with existing property rights.
Thank you, Abigail. Director Gephardt, the first half of this bill is pertaining to easements, which isn't necessarily in your expertise. The second half of the bill mandates that you will maintain on and post on your website informational document. Would you like to comment on that? Is that acceptable to you?
Mr. Chairman, thank you. And I would make one suggestion that rather than the Board of Control shall maintain, maybe the state engineer shall maintain and post. But really my only concern with paragraph E is the upkeep of it, the updating and who does that and when, because this is kind of outside of our expertise, and the document that we have right now was more of a tool just because we got a lot of questions. And it was just some information that we could provide because we try very, very diligently to stay out of these conversations because it is outside of our purview. So I guess if there was one concern of mine, that would be it, is how frequently do we update it, and is it our responsibility to keep it updated as it is property law and not necessarily water law. So I guess I would pose that as a question to consider.
Very good. Thank you. We'll consider that when we work the bill. Committee, it's appropriate to take public input before we actually work the bill to make sure the input is valuable for us when we're redlining. And so I would open the floor up. Would anyone like to provide public input on this topic? Mr. Lockhart, come on forward. You have a visual aid for us. Thank you. Mr. Lockhart, is the handout the same as the visual aid? Is it, or is it different?
Mr. Chairman, the handout is the same. There's also some additional language that is not on the handout.
Okay.
I apologize for not putting that online for the committee members that are not here. But I do apologize for that. Sorry.
We'll try to work. Maybe we can get a camera to shoot your map and see if we can bring that in for the people online. Representative Nyman, would you rotate that map toward that camera for us, please? Mr. Lockhart, the floor is yours. Proceed.
Mr. Chairman,
yourself,
members of the committee, thank you very much for coming to our side of the state, and thank you for your time and your service. A little bit about me. I was born in Pavilion on a farm over there, and I've been trying to grow stuff in a desert for the better part of my life. I'm now in Jackson. My wife's ranch, or my wife's family's ranch, is Lockhart Cattle Company. It's adjacent to the town of Jackson. So that's what the map and the handout shows you. We have the ranch has been in the family about 100 years. give or take. It was put together in various pieces. This is one of the portions of the ranch. We have 4 or 5 other pieces around the valley. This one is the most, I will say, problematic. I'm going to speak first to the item at hand, the bill, in terms of just having access to the ditches. I want to give you a little lay of the land here. So our ranch is adjacent to the town. We see the Jackson Hole High School on the upper middle part of the ranch that we sold to the school district some time ago to help educate the children of Wyoming. We also have a little parcel under contract with Central Wyoming College adjacent to that school for educational purposes. We have 3 points of diversion on this map. 2 are located in town. I was going to make comment on your prior discussion about what happens to development and water rights because it gets complicated. We have points of diversion now in town. We also have one, as you can see, within the ranch, another point of diversion just south of the high school. We have people coming to these on all of these ditches, not only on this place, but all over our property. And for whatever reason, wanting to change the head gates. And as was explained, when many people have water rights and there's a presumed ability to maintain the ditch, that gets fairly difficult. So I'm glad you're working on a bill. I've provided some language that basically says if someone is using those easements that they do destruction to property, that's not okay. The state engineer's office says when you call them, they say, yeah, it's not okay, but we don't get involved in that. As I was saying before, please file suit. I've added language that I can actually call the sheriff. Because if someone's, hooking their 4-wheeler on my head gate and pulling it out, so I no longer can divert water, which I had happen this summer, I have no remedy and I have no recourse. So that's one of the parts of the bill, or one of the parts of the handout that I gave you. The other one is a little bit more complicated. And so bear with me if it seems like I'm off topic, Mr. Chairman, but they are all tied together. So Flat Creek is actually our means of conveyance. So sometimes we talk about creeks, sometimes we talk about ditches. In this case, we divert water from the Gros Ventre River through the National Elk Refuge onto all of the ranches really in South Park, which is all of the area south of Jackson. So the Flat Creek is actually a means of conveyance as well as a ditch. So our points of diversion within there are subject to their locked head gates. So for the most part, those locks are respected. I say for the most parts, we've all had locks cut. We've all had people change our head gates. Flat Creek freezes in the winter from the bottom up. It's called anchor ice, sometimes frazzle ice. And so as it freezes from the bottom, then the water that is still in there is forced up. And as the ice builds up, then there's no place for that water to go, but it overtops the banks. So as it overtops the banks, it obviously floods the development that is adjacent to the creek. So this has been an issue from the beginning of time in Jackson. It's also a common problem in Bozeman. Bozeman Creek comes through the downtown Bozeman, and it's also another creek that freezes from frazzle ice. So it can be solved a couple of different ways. One of the solutions is, in the old days, when it wasn't a big deal, you'd put tracos in the creek, a 320 cat, and You move the ice out and you get the water to go downstream. Of course, when you do that upstream, then what happens to that ice is it comes downstream. And as we know from managing watersheds, what happens on one part of the watershed affects other parts of the watershed. So in this case, when that option is used, that ice, as you can imagine, the map shows the creek coming down, it ends up on our property, and then it starts to build up. It catches a side, on willows on the creek. We have a little bridge that we use to feed livestock on both sides of the creek, catches on that bridge, and then causes flooding and damage. I've got employees out there. I've got my son out there dealing with ice on the creek and flooding, trying to save our bridge to feed our animals when it's 30 below zero. So that's problematic. Also, when those tracos end up in the creek, one of these points of diversion has a low head dam. Typically, the tracos have not destroyed that point of diversion, but the rock weir I have does get moved around by tracos. When I call the town and or the water improvement district that's in place and say, hey, you've done some damage, they say, oh, no, thank you. We're really not interested in that. So another way that you deal with icing is you drill wells and you take groundwater, which is warmer than the creek water, i.e. air temperature, ambient air temperature at -30, and you pump warm water into the creek. When you pump warm water into the creek, then you do not allow the creek a temperature that will build the anchor ice, and you melt the anchor ice, and you actually allow the creek to stay in the channels. Now, the town, fortunately, has 3 of those wells, and they're noted on your map. One of them is just off the map. One is in the middle of the map. One of them is on our boundary. I'm here to ask for a little help on operating these thaw wells. These thaw wells were put in 30 years ago, not quite, to solve this icing problem. And the icing problem and the points of diversion and the irrigation are all tied together. So what happens is we've been there for a while. The town councilors, they turn over. The planning staff, they turn over. The mayor, they turn over. I'm not a bashful person, as you may have guessed. So I have talked to these people for the last 50 years. And for the most part, in the old days, Mr. Senator Grew would understand. You call Mike Yockel and you got it fixed. And you call the mayor and he said, yeah, no problem. And so for a long period of time, we were kind of able to work together, but now times have changed. And so 2 years ago, Christmas Eve, thaw wells aren't on. Icing is happening. They're operating one thaw well in town to protect the town property, but the one that is put on our property, which was put in to mitigate the damage when they put tracos in the creek, as well as mitigate the damage to their bridge, which is High School Road, is not on, and they won't turn it on. And I'm talking to the mayor, I'm talking to all of the people that would have the ability to flip the switch and turn it on, and they won't turn it on. So it caused some significant flooding, some significant damage. I wasn't sure I was going to get the cows fed, quite honestly. So I've been working on this for 2 years. This is Christmas Eve 2 years ago. I can't get a solution. I can't get an agreement with the town, with the improvement district. They have buried our ditches. You'll see pipelines here from the point of diversion to our property. Fortunately, we have agreements in place that says, you need to monitor these pipelines to see if they're plugged. Because when we allowed them to bury our ditches, fortunately, we had an attorney that was kind of smart, and he said, well, you ought to have an agreement that says If they get plugged, they're responsible for maintaining them. If they wear out, they're going to fix them. And so we have an agreement with these entities. And I've asked for those agreements to also be upheld. And I ask all of the people that I told you about, and I don't get answers. I can't get any response. They're the government. And it's sometimes hard to get the government to live up to agreements. And it's also sometimes hard as a private individual to get remedy. So I'm here today, quite honestly, asking for your help. And I think that you will find other agricultural producers around the state as development occurs with their farms or with their ranches, where you're going to have these sorts of issues. So what I'm asking you to do is to look at some language that I have submitted to include in a bill. I'm not pretending to know which bill is appropriate. I'm not pretending to know how that happens. I'm kind of new at this. But I am hopeful that you will look at our situation and say, hey, we really should take a look at this. I might mention a couple of other things. So I mentioned the school, I mentioned CWC, I haven't mentioned Highway 89. We worked with YDOT to allow expansion of that roadway, worked out easements, and we are currently with a restoration project on Flat Creek. So sometimes the old timers didn't exactly take care of our watersheds, and our family may have not been perfect either. So we have been involved with a restoration project on Flat Creek on our property for a number of years. Actually, I've worked with Game and Fish, and they're the lead on this. We've been doing stream restoration on our ranch since 1951, when the levees on the Snake River were built. But we have one currently in progress. Phase 1 has been completed, and that's the stuff below the ranch bridge, kind of right where Lockhart Cattle Company is on your map. And we have phase 2 that's going to occur this year. So last year, when I couldn't get the thaw well on, and we have track hosed out there because we do our stream restoration in the wintertime, causes less damage, and we ended up with some massive flooding, some ice, because we couldn't get the thaw well on, which caused some major construction problems with our stream restoration project. I might mention that our stream restoration project has about 16 or 18 cooperators. Again, Game and Fish is the lead, NRCS, we have federal, state, local agencies, NRCS, WWNRT, Trout Unlimited, we have the local community foundation. I mean, this is a cooperative, collaborative effort to make Flat Creek a better, more functional stream. I mean, I don't know of anyone that wouldn't be for it. We have a long list of cooperators. We have our neighbors here that are not being helpful in that project. My concern for this coming winter, which I have been trying to get an agreement to get this thaw well turned on. They actually have an ability to computerize them now. The computer feeds the inputs, air temperature, water temperature, all of that sort of stuff. And these thaw wells run automatically. The ones in town operate that way, but the ones next to our property, they won't do. I'm concerned that the restoration project that we have going on that is adjacent to this thaw well may end up inundated with ice. And the last time this happened, 2 years ago, we had to put track hose on our property to take care of the ice that the town and the improvement district sent our way. First time in 50 years. Actually, the first time the ranch has ever had to do that to mitigate this flooding and to try to save our bridge to feed our cows. So I'm concerned that this restoration project that's going to go on this winter will be in jeopardy if we're not able to work that agreement out. I come to you wishing that I was not here, wishing that I was able to work this out.
You paused. Are we good?
I'll answer any questions. Maybe I'll just leave it at that.
Your cause is worthy. We sympathize with this situation. I'm trying to struggle in my mind how we can help you. And committee, the bill we have in front of us actually has a slightly different twist than what Mr. Lockhart's talking about. And I'm concerned about implementing this in this particular bill because of the logistics of how to do that. If we're going to help Mr. Lockhart and sponsor a piece of legislation, I think it needs to be a separate piece of legislation than the draft we've got right now. What's your pleasure, committee? Do you have any thoughts on how we might be able to handle this situation? Senator Grew.
Question. I tend to agree with what you're saying. I would like to see us figure out see if there isn't a way the committee, if it was so disposed, either to come up with a separate bill. But before we get to that, I guess I'd like to ask maybe the committee a question. If this language that Mr. Lockhart presented to us was a little less prescriptive to to this situation that he's bringing, which is fair because he's the one having the situation. But if it was a little less, it was a little more brought in keeping with the legislation we're looking at, would that bring it around to close enough to get in there, or is a separate bill the only way? And then if that was the case, if that was the committee's feeling, would the committee be interested in taking that up as a committee bill?
That's a good question.
Mr. Chairman.
Members that are online, and Abigail, you don't have a copy of what we're looking at, do you?
Nope.
Mr. Chairman, I do not, and members online don't either. If there's a way to get it emailed to me, I can get it sent out right away.
Send out doesn't really help us in this meeting. So regardless of whether it fits in or we need to look at separate piece of legislation, we can't act on it today because our committee hasn't had time to look it over. So members, if you're interested in taking up this concept, I'd suggest that we visit with LSO and have them look it over and to see how the best way would be to handle it. Let our attorneys advise us on that and come back in our next meeting and discuss it further. Or otherwise, the other alternative is to tell Mr. Lockhart, thank you very much, but we're not interested in taking up this topic. That would be another alternative. Senator French.
Thank you, Mr. Chairman. A question for Mr. Lockhart. These thaw wells that are in town are existing wells. From what you're saying, they've been used in the past. Why won't they flip the switch and turn them on? Are they worried about the water table, water wells for the town? Or so somebody was in agreement at some point that, yeah, this is a cure for the creek freezing from the ground up. And I don't know how many years they were used, but why now would they not allow that those wells to be flipped on to mitigate the problem?
Well, there are some explanations that I get. I feel a little uncomfortable speaking for them. I think the answer is, times change, people change, reasons change. We've inserted a water improvement district in here where we never necessarily had that 20 years ago. That water improvement district or flooding, it's not water improvement, excuse me, flood improvement district asked me to be a member of it. I thought it was a bad idea. I didn't want to be a member of it. I thought that it was easier to deal directly with my elected officials as opposed to another district in between them and I. And so I chose not to. And that district said, well, you chose not to be part of the district. We're not going to help you. I mean, those are paraphrased words. Again, the town, depending on who I'm dealing with in the town are sympathetic. I've had people that have been willing to turn it on for a bit of time, and then all of a sudden it gets shut off, and I try to figure out how and why. And so the answer to your question, it's better. It's better that I guess they would answer that. I suspect that if you decide to put this in a bill or make it a bill, that we'll have that discussion in front of you at another time. And you know, the answer is, unfortunately, as people change, it will be important for us to have language in the statute so that the consistency of operation is not whimsical, and that there is direction in terms of managing a watershed and being a good neighbor. And like we've talked about, being a good neighbor, you know, ebbs and flows. And so just like your bill that talks about easements, all of a sudden there becomes a need to codify that being a good neighbor policy. And so I would argue that regardless of whether I can get it turned on or can't get it turned on, it is important to codify being a good neighbor in this particular case.
Very good. Thank you, Mr. Lockhart. Committee, I'd propose that we take this document that Mr. Lockhart has provided to us and ask LSO to think that through and give us a recommendation on how we might approach it. It may be too late bringing this back for this year. Mr. Lockhart, another option you have is to ask your Teton County representatives to sponsor a piece of legislation. They can literally run it as a member of the legislature as well. And that would certainly be something in the time frame to get it addressed this coming year in the session. But that's what I recommend, Council, particularly since our online members don't even have a copy of anything. So let's just take it under advisement. Is there anyone who would object to that? Okay, that's what we're going to do. Thank you for your input.
Thank you.
Anyone else in the public would like to testify on this bill that we're looking at right now for prescriptive easements? Mr. Neal, are you stretching or do you want to come on up to the mic?
I'd like to come up, but I testify is a strong word. But first of all, I'd like to thank the committee for the work that you're doing. We appreciate it. We recognize that unlike maybe some of our counterparts in Washington, you're not getting rich doing this job. And we appreciate you doing all that you do to try to make Wyoming a better place to live and to work. My name is Joe Neal. I am on several water organizations, Crow Creek Canal and Water Master. I'm the president of Neal String Sprinkler Company. There's a couple other smaller, tighter groups on down Salt River that I oversee and run, irrigation companies. I have a comment on, as you guys are working on codifying some of these easements and our abilities to maintain our ditches and our pipelines. The way I understand the current statute is that we have the ability as a ditch owner to maintain our ditch, but a landowner that is not on board with us maintaining our ditch can stop us from maintaining our ditch, but they have to maintain it to a legal specification. The problem with that is there's no teeth in that, and I've been involved, I haven't been involved personally. It was a users on our canal system this last summer. The sheriff was involved. And Sheriff Johnson, and I asked him after the one user wanted to maintain his ditch through another landowner who also used the ditch, the same ditch, to convey water to their property. And interestingly enough, this is a family that's been here 100 years, and they're both descendants. It's not a move-in that's blocking the old user. They're been fighting for a long time. But when the sheriff came in, I asked Sheriff Johnson what his stand on it was, and he says until he has either there's a threat of violence, he will not intervene other than to disperse him, saying you can't clean your ditch, you need to leave. And the only way he would enforce that is if he had a court order. So the issue is it's costly to take these things to court. A large entity may have the funds to pursue that, but small users don't. And so what's happened there is the user that wants to use his water has essentially been blocked from his water. And he has no recourse other than spend the money to hire lawyers and go to court. I just wanted to relay that to you and in your consideration of codifying our easements and our ditch rights, that's happening, at least here in these situations. Another situation, and I would have liked to have been here this earlier for the discussion on the ponds, but I was actually working on digging up an irrigation line that runs under Highway 89, and we have a big leak in the middle of Highway 89. And this brings me to my next question or concern. Our easements, and in this valley specifically, there's a lot of water runs under the state highway. There's several companies with several spur lines, some of them that comes from the east side, irrigates land on the west side of the highway, and they come under the highway. It's been my understanding, and I haven't personally had to deal with this to this point, with this water leak. I may have to. The expansion of Highway 89 in the lower valley, it was pretty common knowledge that DOT was pretty adverse to those lines coming under the highway. The users, and these were small irrigation companies, wanting to basically, well, they wanted to put an HDPE pipe, which is if you're not familiar, is a pipe that once in place is fairly indestructible. So it would be there. It would protect both the irrigation users and the highway department and the safety of the highway system. DOT was not willing to let them put those in. I don't know if that was ever negotiated to the point where they did allow those things. I didn't ever see any evidence of it. The point of it is how good are our easements for our irrigation lines? We have on our Neil String sprinkler, we have deeded rights of way. What does that allow us to do? What can we do? Like a situation with my line that I worked on this morning, does that allow me to dig up the road and replace that at some point? Or do I have to incur huge expense and boring costs and other things, even though I have an easement, a deeded right of way, and the highway was built over my easement. My easement predates the highway and the ownership of Highway 89. I just like to point those things out, and something for you to think about in considering putting more teeth into our laws. Thank you. If you have any questions.
Thank you, Joe. So the bill in front of us that we're entertaining is not going to give you a lot more strength as a water user. What it does do is it defines a prescriptive easement and makes the judge, there's no question about it, the judge is going to slam the gavel as you present the information. So you're still going to have to go before a judge in order to have a prescriptive easement identified and quantified for you to be able to maintain your ditch. So we're helping you, but I mean, your attorney is going to be able to point to this when it's in statute and say, bam, bam, I've met these, away we go. But we're stopping short of going as far as you would like us to do. Any comments?
Thank you.
Good, thank you. Any other comments? All right, thank you. You're being great. Sorry, we're going over time. Members, we're ready to work the bill. Are you ready to work the bill? Senator French.
Thank you, Mr. Chairman. In this, it seems fine to me, except I don't see anywhere where the width of an easement is described. Now, if somebody has a dirt ditch across that's been there 50 years and then across 2-3 landowners, and they need to come clean the ditch out, you know, if that easement's in place. Backing up a little, the cross is somebody that has 5 acres or whatever and a really nice home, and depending on where they're at, you could be talking $1 million plus, right? Well, any easement's kind of a cloud on their title. And I think there should be some discussion on the width of those easements, like an open ditch or a buried pipe, a 24-inch pipe or whatever it is, that they can come in there, you know, a 30-foot easement, 15 foot on each side of the ditch, or that way you can get a track hoe in there and you can dig the ditch out, the silt and grass out of the ditch, or the pipeline breaks, you can dig down to it. And so an easement would need to be big enough to get the job done, but yet, you know, it's kind of wide open, you know, it doesn't need to be bigger than it should be, I guess is where I'm going with this. You know, it
Okay.
doesn't need to be, if you have an open ditch or a buried pipe, doesn't need to be 100 foot, 50 feet on each side, you know, that's pretty big ask of that landowner that the ditch crosses. But, you know, it needs to be something, I think, I just bring that up.
Okay, Senator French, that's a really important issue. Now, Abigail, as I understood the background on this, you indicated that case history of other court cases have indicated that the judge makes that determination, and that you recommend we not talk about specific footage in this bill. Is that correct?
Chairman Simpson, I don't think you can establish by statute specific footage of a prescriptive easement, because it depends on what was established 100 years ago, really. And so until you prove that and you establish you have an easement and the court decides what you historically used, you can't go in and say every ditch in the state gets 20 feet. Now, I know Representative Larson sent out language from Idaho. Now, these would be, once you've established that you have an easement, this is clarifying that you have a right to access and to use that easement. But you notice even in that language, it's saying you can't encroach on the easement. The easement's defined by whatever the easement has been established to be, whether that's recorded or established by a court. So once you get it established, no one can encroach upon it according to this Idaho law, but you can't go in and establish easement widths in statute for existing potential prescriptive easements, because they're so fact specific.
Thank you.
Fact specific.
So Senator French, the answer is you want to get detailed, and our legal counsel has told us not to do that. It's not appropriate.
Mr. Chairman.
Follow up, Mr. Chairman. You know, I get it, but there hasn't been an easement across it. You're wanting to do an easement, you're wanting to establish an
There's
easement.
nothing in writing, correct?
So it's a new thing. Maybe it's been crossing there for 100 years, but now we're wanting to establish it. There hasn't been an easement, I think is the deal. now we want to establish an easement. And then that person on page 2, line 20, they file a notice describing the easement in the office of the county clerk in which the easement or a portion of the easement is located. What prevents them from saying, I want 200 feet? I want 100 feet on each side of my ditch.
Abigail,
Am I
your answer is the
missing
judge is
something?
going to make that decision. The challenge, Senator French, is a canal that's as big as this room is going to be a completely different easement width. And if you got a dinky little, so one size doesn't fit all, and we can't even do right in statutes a range or anything. Abigail's suggesting that that would be inappropriate.
Mr. Chairman, I get that if it's a major canal, but if it's a ditch across there or a buried pipeline, it seems pretty wide open. I was just trying to narrow
hear
the
you.
description down.
Representative Larson.
Yes, Mr. Chairman, thank you. I think everything that I've always dealt with, it's always said that it's what is reasonably needed. So then I know that's very vague, but I think people that have worked on ditches would know what they need. I also want to make sure that we realize the Bureau projects have the 1890 Canal Act that tells them that there is an easement there before the lands were patented. So those districts don't need to worry. They have a right of way and easement through the federal government. I also think there's probably any Carry Act districts or irrigation districts that were done under that probably have a easement already provided. It isn't described, but it is there by law. So I don't know. If we're going to go at this, I sent out that Idaho bill. I think if we're going to go at it, let's go out with some teeth that actually have some wording in there that says, you can encroach on it and all of that, because all these districts are dealing with it. So if we're going to go do it, let's go all out and not mess around.
Any other comments? Okay, we're looking at the bill, folks. So I'm going to throw a question out for Abigail on page 2, lines 6, 7, 8, 9, 10. Abigail, on line 6, it says continuous and uninterrupted. But many of our ditches do not have water in them in the wintertime. Does uninterrupted mean you have to always be conveying water through that ditch?
And Mr. Chairman, I'd have to look into that and to see what the case law said. I think this is why it goes to court.
Very good. And
We
so
prove
while you're
it.
looking into that, let's look into line item number 11. I don't know what the word adverse is. So when we come back, assuming we table this for next time, would you give us a definition of adverse? Any other comments on the bill? I know the word notorious in the previous line.
Mr. Chairman.
Senator Grew.
Thank you. I recall from, there he is, Mr. Gephardt's testimony before. On page 3, line 14, you said you had some questions about length of time and about the Board of Control. Do you have a suggestion on what you'd like to see there?
Director Gephardt.
Thank you, Mr. Chairman. The one comment was that the document would be posted on Board of Control website. My suggestion was to change that to the State Engineer's Office website.
Very
And then
good.
my
It's
other
on line
question,
14, page 3. Proceed.
and then my other question, and I don't know if I have a solution yet or not. But it regards the updating and maintenance of this document, who's who should be responsible for that?
So someone has to write the document in order for you to post it. Is that what you're saying? You don't want to be in a
Well-
position to write it because your staff is not attorneys?
That's correct. And we do use a document now that was prepared years ago as an example of here's some things to look at and consider. And I think that's probably what was being referred to in this, but as laws change and time goes on, these things need updated periodically and or frequently. And we're not attorneys and I don't know that we should be updating them as a state engineer.
Thank you. Representative Larson, you just sent us an Idaho state statute that we haven't had a chance to review yet. We appreciate that, so we need to study that out. Any other wording? Let's fine tune this document a little bit. We're obviously going to table this for more questions and answers, and we have a chance to look at Representative Larson's input. Is there anything else on this? So we need to make a note on page. So I'm going to, well, Senator Greer, would you make a motion to change page 3, line 14?
Sure, absolutely. On page 3, line 14, delete the Board of Control and add state engineer.
Do I have a second? All in favor indicate by raise their right hand. Any opposed? Seeing no opposed, that passes. Any other tweaking of this document?
Mr. Chairman.
Senator Steinmetz.
Thank you, Mr. Chairman. Did I miss where we moved the bill to be amending it, or I thought we were tabling it, so I'm a little confused as to what we're doing.
You did miss that because the chairman didn't ask for a motion. Thank you very much for keeping us on track. So the first, let's see. We're still considering it. Are we ready to move this bill, or are we still just redlining it in advance to making a motion? What's your pleasure? Are you ready to move the bill? We can still table it afterwards. What's your pleasure?
Mr. Chairman, I'll move the bill.
Senator Grew, you're moving that we advance the bill. Is there a second? I moved and seconded. Any discussion? And we'll adopt your amendment because that makes sense to everyone. We're good there. Now the question is the motion to move the bill, get it off our slate and publish it? Or is your motion to advance the bill and keep it and
Mr. Chairman, my intent was to move the bill to amend it, and then if it's the pleasure of the committee to table it at that point, then it can.
okay? So let's see, I need to call for a vote on moving the bill. All in favor, raise your hand.
Wait.
Oh, Representative Larson.
Mr. Chairman, I'm lost. So we've moved the bill to discuss it right now? Is that
Just
what
to
we're doing?
discuss. Correct.
Okay.
We're not finalizing it at this point in time. I apologize for. So
Mr.
let's see,
Chairman,
we have a motion. Representative Paxton, go ahead.
I believe the proper procedure at this point would be to move to table the bill and not to move the bill.
Thank you.
So in my old FFA parliamentary procedure things tells me that that would be the proper course of action at this point.
He's also a chairman of the Education Committee, and that's why he knows proper protocol. Thank you, Representative Paxton.
Mr. Chairman?
Yes, please.
So
Hold on a second.
Mr. Chairman?
Representative. All right, go ahead.
Is it that we're tabling it till the next meeting, correct?
Or Senator Guru is going to withdraw his motion, and then we'll be looking for another motion. Go ahead, Senator Guru.
So, I'd like to withdraw my motion to move the bill at this time.
Withdraw second. Okay, now we're back to square one. Representative, would you like to make a motion?
Mr. Chairman, I move that we table the bill until the next meeting.
It's been moved and seconded that we table the bill. Any discussion? Okay. Very good. We'll vote on that. All in favor, raise the right hand. Any opposed? Okay, very good. We're tabled. So there's no more discussion on this bill and this topic. And that brings us to the bottom of the agenda. Thanks, everyone. It's a good thing that we're over because my mind's wearing right out for the day. Thank you for everyone for attending. Our staff with the Water Development Commission. Director Mead, thank you for all you do for us to keep us going. And we sure appreciate your staff. You've got such good people working for you. Before we go, I would be amiss not to announce that we're losing our attorney, Abigail. She's taken another assignment in the state engineer's office. And so this will be her last meeting that she works with us on. Abigail, you've just been a joy to work with. Thank you for your support and good legal advice. We wish you very well in both the birth of your baby and your new career after the baby's born. Thank you very much. All right. Senator Grew.
Yeah, just real quick, want to thank you on for your hospitality and your families for your hospitality and everybody who helped with the tour today. It was awesome. And I know that we all really enjoyed it. And I always enjoy our time in Star Valley, but this was very special, and the cookbook and everything. Thank you very much.
You're welcome. All right. I don't remember. Do we need a motion to adjourn? We do. Senator or Representative Nyman, would you like to make that motion? Any second? Seconds. All those in favor indicate by the raise of the hand. Thank you very much.